Is that all right now? Sorry. You ready? Okay, well, good morning, everybody, and welcome to day 6 of the hearings, including to anybody observing from the council chamber. It's 9:30, and today's hearing is now open. My name is Louise Phillips. You not hear me? Back? Not working? Try it. Can you hear me now? Yep, okay. So my name is Louise Phillips, and I'm the inspector appointed by the Secretary of State to examine the Epping Forest District Local Plan. The programme officer, who many of you will have met, is Louise St John Howe, and she's responsible for the administration of the examination to assist me. And outside of these hearings, she is the first point of contact for you. Please could I just ask anyone with a mobile phone to switch it off or turn it to silent, and if I could just ask the council for a reminder of the fire procedure and where the bathrooms are, please.
Okay, so there's no planned fire drill today. So if the fire alarm does sound, you need to leave by the fire exit through the door that you came in, down the stairs and assemble on the green opposite. If for any reason that exit is blocked, there is an alternative exit behind me and down the stairs at the rear of the building. The toilets are located on the stairwells as you came in through the council offices on each level.
Thank you. So the council has asked me to remind everybody present that this meeting will be filmed and broadcast live to the internet and will be capable of subsequent repeated viewing, with copies of the recording being made available for those who request it. So by being present at this meeting, it is likely that the recording cameras will capture your image and your image will become part of the broadcast. You should be aware that this may infringe your human and data protection rights, and if you have any concerns about this, you need to speak with the webcasting officers to my left. Please could I also remind everybody to activate their microphones when speaking, because otherwise anyone watching the broadcast can't hear what you're saying. Thank you. Does anybody else here intend to record or film the hearing? Okay, well, we'll move briskly on to the agenda, but if I could, there's a couple of things before we start, but if I could just first ask everybody here to introduce themselves. Thank you.
Good morning, Madam. My name is Mark Beard. I'm a barrister instructed by Epping Forest District Council on behalf of the Local Planning Authority. And to my right is Ms. Alison Blom-Cooper, who will be speaking this morning, together with Miss Chloe Salisbury to her right from Arup. And to her right again is her colleague, Mr. William Marr-Heenan. There'll be other participants from the council later today dealing with issue 4.
Yeah, good morning. My name is Ed Kemsley. I'm from Peacock and Smith. I'm here representing my client, Stallen Nazing Limited. Thank you.
Good morning. Oliver Bell from Nexus Planning, representing St Congo Provincial.
Good morning, ma'am. My name is Stephen Koski from Turley in Cambridge, representing Land Fund Waltham Abbey Limited for a site at Upshire Road, east of Waltham Abbey.
Good morning. My name is Jonathan Hawes. I'm representing my company Loughton Self-Drive, and we're part of the Loughton R2 site selection.
Good morning. Rachel Bryan from Saunders on behalf of Mr Martin Eldred with the land interest at North Weald Bassett.
Morning. Trevor Dodkins from Phase 2 Planning, representing Bloor Homes.
Good morning, I'm Danny Simmons, I'm from RPS and I'm acting for CK Properties Thaden Boys Limited.
Good morning, Nick Island from Iceni Projects on behalf of Bullwood Limited.
Good morning, I'm Tony Asprey Planning, representing Freetown Homes.
Good morning, David Mosley from Persimmon Homes, Essex.
Good morning, Catherine Williams from Savills on behalf of Redrow.
Good morning, Neville Surtees from Barton Wilmore, representing Higgins Homes.
Morning, Sanjeev Shah, landowner at 146 Hainault Road.
Good morning, ma'am. David Churchill. I'm representing Countryside Properties from Carter Jonas.
Good morning, I'm Jessica McSweeney from Carter Jonas, representing London Square's land interest at Chigwell.
I'm Olivier Spencer from Andrew Martin Planning, representing Miller Homes for the East of Harlow site.
Morning, Madam. My name is Reuben Taylor, QC. I'm representing Quinn Estates.
Good morning. I'm Rachel Allwood from Dandara Limited in relation to Temple Farm in Roydon.
Good morning. I'm Mike Newton from Boyer Planning, representing CEG and Hallam Land Management.
Good morning. I'm Paul Belton, as you know, representing Pigeon Investment Management, but also today to save a seat at the table, I'm representing Chisenhale Marsh Estates on behalf of my colleague also.
Well, thank you. Obviously, I'm keen to turn to the agenda. There's just a couple of things, perhaps before we start. I wondered if I could just ask the Council to produce a list of the statements of common ground that it has signed, either those which are signed or in progress, and sort of keep a running copy of those. Obviously, there's quite a lot of them coming up now, and that would be helpful. And if you could sort of keep that, and then at the close of the hearings, if I can have a final copy. Thank you very much. Just a quick.
Sorry to interrupt you. Nobody can hear.
Right.
Nobody's talking into the microphones, and they have to go.
Okay.
They have to talk directly into them.
Okay. Okay, so that was nobody can hear. Can everyone hear me? Okay, so I think what we probably need to do is just try to bring the microphones a little bit closer when we speak. It might be the background noise. Okay. Okay. Thank you. Well, sorry about that. If you can't hear, wave, and I'll try to stop it and see if we can repeat it. Just a quick reminder of how today's session will run. Obviously, it's split into two with the same agenda this morning and the afternoon. And I know there's a lot of you and you'll have a lot to say, but I'm keen to stick to the times in order to be fair to everybody and let everybody have the same opportunity. So I'm going to run the hearings, as I said in my note, slightly differently, essentially trying to take the three issues on the agenda. I've combined issues 1 and 3 because they essentially concern the same site selection process. And really try to take most of the matters under each main issue together, allowing everybody an opportunity to just say what they want to about any of the sort of sub-matters that arise. Issues 1 and 3 are quite long, and I will break that up slightly. So I'll come on to that in a minute. As a slightly different matter, I just wanted to draw everybody's attention to a letter that I received from Mr. Simmons on behalf of CK Properties. Has the Council in particular seen that letter? Thank you. So Mr. Simmons, as you heard, is acting on behalf of CK Properties, promoting a site in Thaden Boys, and is concerned, I think, and you can obviously correct me if I'm putting words into your mouth, but is concerned that I've asked you to address primarily points of principle and process rather than going into detail about the merits of particular omission sites. Now, on that point, I just wanted to remind everybody that in my guidance note, I did explain that omission sites are not normally discussed in detail, but rather, if additional sites are needed, then the Council will need to decide which ones to bring forward. And this could be for various reasons, including potentially any issues to do with the site selection process. But either way, it won't ultimately be for me to decide which additional sites should be promoted, if any of those are in fact required at the end of the day. So the implications of the CK Properties judgment in terms of fairness and legal compliance was considered on day 1 under matter 1, and you are today able to express why you think the wrong conclusions, if that's your case, have been reached as a result of the site selection process. And I fully understand that some of you might wish to refer to omission sites to illustrate those points. And I do ask specifically whether on the agenda any changes to the plan are required as a result of the comments made at Regulation 1920 stage, and this could include comments made supplementary in relation to the site selection appendices. So I suppose that's my position set out, and that's an explanation of why I've decided to run the hearing as I have. But I will just put it to the Council in fairness to say, on this basis, I wonder whether the Council would wish to comment on whether it still considers the issues raised by the judgment can be addressed through the examination process. You can reply now or later, that's up to you, but it's not going to change how I intend to conduct this hearing today. Is that clear to everybody? Okay, let's just ask the council for a brief comment on that before we move on.
May I say on behalf of the council at this stage, we'll reserve our position generally in respect of matters that we've addressed previously about the fairness of the proceedings. Nothing thus far causes us concern, and we certainly endorse the approach that you're proposing to adopt today.
Thank you. Okay, then moving on to the agenda. So issue 1 and issue 3, which related to employment land, is have the plan's housing and new employment allocations been chosen on the basis of a robust assessment process. Now, I'm assuming most people are here to speak about the first bullet point primarily. So what I'd like to do is take the first bullet point on the site selection and sifting process, combined with the second on the historic environments, and I'll clarify what I think about that in a minute, and then actually skipping one, and the fourth on the proposed modification to delete the sequential approach to the allocation of housing sites within policy SP2A. I'm going to ask the council to comment on each of those bullet points in turn so that you've heard everything that the council has to say about them, and then we'll go round the table in relation to those 3 bullet points before moving on to the capacity of suitable sites and the car park issues, which I think stand slightly differently. Does anyone have any fundamental concerns with that approach? No. Okay. So beginning then with bullet point 1, on the site selection sifting process. I won't read them all out, you can all read them for yourselves, but where I have particular questions, I'll just highlight those now. So the first one, the justification for the buffer zones as a major policy constraint at stage 1. Just want to understand what those are, where they're defined, and what the purpose is. In relation to the second point, the transparency of the officer and member workshops has been raised a couple of times. In what form was the outcome of these workshops available for public scrutiny? The others, I believe, are self-explanatory. Moving down, 6, perhaps in light of the comments I've just said in terms of the Thaden-Boyce issue, do any errors reported in response to the Tranche 2 sites or Tranche 1 sites through the Regulation 1920 process necessitate amendments to the submitted plan? Perhaps if you could sort of focus on that matter. That's all. I think that's all for now. So if I could just ask the council to address those points, and then we'll move on to the historic environment. Thank you.
Thank you, Madam. As you appreciate, there's quite a lot to get through, and I apologise for that in advance. The site selection process was a collaborative process undertaken by the council jointly with ARUP, and that's reflected in the site selection methodology, the report and its appendices. I'm going to ask Chloe Salisbury from ARUP just to set out very briefly the site selection process, because I think it's helpful for us all to understand the process that was undertaken at the outset. And to aid that, we have circulated a diagram.
Can I just check that everyone has copies before I start speaking? If anyone could raise their hand if they haven't got one. Everyone hear me? So the detail of what I will just cover very briefly can be found in section 2.2 of the site selection report, which is EB 805, and the detail is covered in the site selection methodology, which is EB 805 AK. At the top of the piece of paper, it says it's an overview of the residential site selection process. In relation to employment sites, it is broadly consistent. The main difference is that in 2016, the council paused the employment site selection process at stage 2, to undertake further employment land supply evidence, and therefore then started it again in 2017 and effectively just did it once rather than twice for residential. What the diagram is seeking to illustrate is that, broadly speaking, the approach adopted between the 2016 sites, which in the site selection report is referred to as tranche 1 sites, and the 2017 sites, which is the tranche 2 sites, were broadly consistent. So the green boxes illustrate the processes that the council followed to identify sites. There are a range of different sources. Where sites were sifted out as duplicates, which I think we've discussed at a previous hearing. That's recorded in the Appendix EB 805B. The first main stage of assessment was an assessment of major policy constraints. There were 6. That's set out in Table 1 of the site selection methodology. The results of that assessment is set out in EB 805AJ. Then we proceeded to Stage 2 assessment, which is for each site, a detailed suitability assessment was undertaken against about 32 or 33 criteria. EB 805E sets out the methodology that was followed for that assessment with the results contained in EB 805F. Stage 3 or stage 6.3 looked at identifying whether sites were suitable, taking into account the stage 2 assessment or stage 6.2 assessment and a range of other factors which are detailed in the site selection report. For space, I didn't detail what steps 1, 2, 3 and 4 are, but they are set out at paragraph 2.65 of EB 805. For those of you that don't have it in front of you, step 1 is identifying suitable strategic options to accommodate growth. Step 2 is assessing site suitability. Step 3 is assigning sites against the land preference hierarchy. And step 4 is identifying sites for further testing. For those sites that were subject to further testing, a capacity assessment was then undertaken. And then stage 4 or stage 6.4, we undertook an availability and achievability assessment. That's the A&A assessment. And then made recommendations on sites for allocation in both the draft local plan and local plan submission version.
Thank you. You just pause there a second. Is there a problem? Right. Okay. Thank you. You aware? No, thank you. Are you the? Oh, sorry. Were you the only people affected? There's nobody else there. Okay. Thank you. Okay. Okay. Thank you, Ms. Salisbury. Do you want to carry on?
That was all I was going to say, Madam, on the process, unless you had any specific points you wanted me to clarify. Okay, so moving on to your question regarding settlement buffer zones. The Council's justification for inclusion of settlement buffer zones is a major policy constraint, so that's stage 1 or stage 6.1 of the site selection process. It's set out in the first row of table 1 of the site selection methodology, which is EB 805AK, page A10 to A11. In this justification, the Council emphasises that the NPPF contains a presumption in favour of sustainable development, which is para 14. This is supported by the core planning principles set out in the NPPF at para 17, two of which are particularly relevant to assessment buffer zones. Bullet 5 talks about taking account of the different roles and character of different areas, promoting the vitality of main urban areas, protecting green belts around them, and recognising the intrinsic character and beauty of the countryside. And bullet 11, which talks about actively managing patterns of growth to make the fullest possible use of public transport, walking and cycling, and focusing significant development in locations which are or can be made sustainable. The NPPF therefore indicates a preference for development to be located in areas which can access services and facilities. In terms of the spatial extent of the settlement buffer zones, I can provide more detail on that if that would be helpful. These were determined through the accessibility assessment work undertaken by Essex County Council on behalf of the Council, which is documented in Technical Note 6, which is EB 500F, and Technical Note 7, which is EB 500G. The settlement hierarchy and the Stage 1 Greenbelt Review. In particular, using the settlement hierarchy, settlements were placed into the most appropriate categories in accordance with the services and facilities available in each location. The analysis then drew on the accessibility assessment that I've just mentioned undertaken by the County Council, which sought to assess the accessibility of potential sites in each location in the district. In particular, Figure 1 in the summary findings of EB 500G on page 2 shows an average level of existing and potential sustainable accessibility achieved by sites in towns and villages in the district. The accessibility assessment looked at a number of accessibility criteria for public transport and other services, including, for example, education and health. This information was then used to identify broad locations for further assessment, which was undertaken in the Stage 2 of the Greenbelt Review, and to apply buffers around each settlement. The buffers used broadly reflect the accessibility assessment findings, and this is set out in page 16 of EB 704B. In this way, the Council identified those locations which it considered represented sustainable locations for new development. As paragraph 18, which is page 14 of the Greenbelt Review Stage 1 methodology, which is EB 704B, explains, hamlets were not considered a reasonable or desirable potential location for planned growth or release from the Greenbelt, given the relative lack of existing services and the emphasis provided in the NPPF regarding sustainable locations. Therefore, towns, large villages and small villages within the district were the focus of areas for search, or the buffer zones. The councils determined that the areas of search will be refined by applying a buffer around each settlement, using existing defensible boundaries where they are present, and that the size of the area of search around each settlement should accord with the categories in the settlement hierarchy. Paragraph 20 on page 16 of the Greenbelt Review Stage 1 methodology sets out the buffers applied. The largest buffer, which was applied to towns, is 2 kilometres and reflects the maximum reasonable walking distance set out in the Essex County Council Accessibility Assessment, which is EB 500F.
Okay, I'm going to move on and cover the role of the officer and member workshops. As paragraph 1.2 of the site selection report, EB 805, explains, ARUP undertook the site selection process on behalf of and in collaboration with the council. It was an inclusive and collaborative piece of work between council and consultants, as the work sought to appropriately engage with officers and members of the council at key stages in the process to ensure the process took into account the available evidence. In the Council's view, this is a proper approach and ensures that the local plan responds to local circumstances to achieve sustainable development. This is a central tenet of the NPPF, as articulated at paragraph 10. It also reflects leading practice in preparation of local plans. The site selection methodology, EB 805AK, at various paragraphs, identifies the role of the officer and member workshops in confirming strategic options and the suitability of sites within more suitable strategic options, and in informing future member decisions which were taken at full council about the sites to include as proposed allocations in the draft local plan and the local plan submission version. So in summary, the purpose of the workshops was as follows. As far as officer workshops were concerned, they were to ensure officers' knowledge of the district, including specialist technical knowledge, as well as knowledge of other evidence-based documents and consultation undertaken in the preparation of the local plan, were fed into the site selection process. The member workshops sought to engage with members. This included briefing members on the emerging evidence-based work and to check for factual inaccuracies in the technical assessment. It also provided an opportunity for members to check and challenge the initial conclusions which had been reached by officers. The feedback from the officer and member workshops fed into the justifications contained in the write-up of the site selection assessment, which is documented in the site selection report and its appendices. And if it's helpful, I can point you to the various paragraphs and sections of the various write-ups, if that's helpful.
Are you talking about appendix, is it B1.6.6?
It's in the references are in the site selection methodology.
Okay, if you point
so
them
stage 3 or stage 6.3 officer workshops are written up in paragraphs 4.28 on page A15. Paragraph 4.72 on page A25 and 4.76 on page A26. In terms of the stage 3 member workshop, that's set out in paragraph 4.30 on page A16. And no workshop was proposed or held for stage 6.3. In terms of stage 4, the officer workshop, we had an extra workshop at stage 4. The purpose of that is documented in section 2.8.3 of the Site Selection Report 2016, and that's EB 501, page 27. The stage 6.4 officer workshop is set out in page A27, paragraph 4.86. The stage 4 member workshop is at paragraph 4.43, page A19. And the stage 6.4 member workshop is paragraph 4.88, page A28, although in fact that workshop was not held. Particularly with regard to member workshops, the methodology was clear that amendments to assessments would only be made where there are clear planning reasons for doing so.
Okay, we're going to move on to were sites assessed individually or as part of larger parcels, as in the Greenbelt review. The approach adopted to assessing the level of harm to the Greenbelt arising from the development of the site is documented in Appendix B141 of the Site Selection Report, which is EB 805E, pages B202 and B203. This is based on criteria 2.1 of stage 2 or stage 6.2 and associated scoring, which is set out on page A33 of the site selection methodology. It's just worth noting that there's a footnote 9 to that criteria, which confirms for the purposes of site selection, ARUP used the results of the sensitivity test from the Greenbelt stage 2 review and only considered the level of harm to the Greenbelt based on the assessment of purposes 1, 2 and 4. In summary, EB 805E confirms that sites were assessed as part of larger parcels. I can provide more detail of what EB 805E says, if that's helpful. There's a slightly nuanced approach, but that's...
Sorry, just what I'm trying to get at is I think it's something that I know that Mr. Bolton has raised in the past. I know he's speaking this afternoon about whether... I think there was something like some 800 sites or whatever that you had to look at. Did you look at at some point was each individual site assessed and put through that process and a conclusion reached about it, or were some sites screened out without you having looked at that as an individual entity? That's what I'm trying to get at, because I know in terms of the Greenbelt Review, there were large parcels that were looked at, and obviously the site selection report takes account of the findings of those large parcels. But ultimately, in the site selection report, is there an individual conclusion for each individual site, or is it still on a sort of parcel-wide basis?
For sites that fell wholly within a parcel, we just attributed the level of harm from the Greenbelt Stage 2. As explained in EB 805E, where sites fell into more than one parcel with a different classification of potential harm, a qualitative assessment was undertaken to determine the extent to which development may harm the Greenbelt. And we took a number of factors into account in coming to that qualitative assessment. Does that help?
I'm not being clear about my question. I'm not really concerned about how the Greenbelt was assessed at this stage. It's not really about, I know that you took, I know that Greenbelt was only one factor, for example, that was looked at in the site selection report. So whether the results of the Greenbelt was taken from a wider parcel assessment or not, was ultimately each site that was put forward has its own conclusion. So it wasn't that any, not for Greenbelt purposes, forget Greenbelt purposes for a moment, was any site just screened out because it was part of a big area of land, or was every site looked at? Okay, thank you. Thank you.
Apologies for not understanding your question.
That's okay. I think I probably didn't help by putting in I think some of the representations I've read have suggested, which I didn't think was the case, that some sites had never sort of made it through the site selection process because they'd been screened out as part of a wider site. Thank you. Obviously, we can hear others' views on that as we go around, but that was just the point of clarity that I wanted. Thank you. Okay, so we can move on from the council to how the information submitted by site promoters was taken into account.
Okay, so that's back to me. The council did have regard to information submitted by site promoters. During the Regulation 18 draft local plan consultation, the council offered meetings to site promoters whose sites had not been proposed for allocation. Those meetings took place on the 18th and 21st of November 2016 and sought to explain to the promoters the site selection process and the reason why sites were not proposed for allocation. And that was specifically undertaken at that stage in order to inform their responses to the draft local plan consultation. Following the draft local plan, a detailed review of the Regulation 18 responses received was undertaken, and through that the council identified any material changes, in particular site boundaries, provided in site plans appended to representations from site promoters. In accordance with paragraph 4.49 of the site selection methodology, those amended site boundaries, along with any new sites proposed, were assessed through the process as the Tranche 2 sites. This list of potential new and amended sites was published on the council's website in August 2017. That's EB 804. And the assessments of those sites is written up in the site selection report. With regard to the site selection assessment, the council considers it adopted a proportionate approach in terms of having regard to all the site promoter information, including flood risk. Specifically in terms of suitability assessment, that's at stages 2 and 3, or 6.2 and 6.3. Where available, the council had regard to the additional information on individual sites, either submitted initially through the call for sites process or through representations to the draft local plan. And that's confirmed on page B191 of Appendix B1.4.1, detailed methodology for stages 2 and 6.2. Paragraph 2.60 of the site selection report, and that's pages 21 and 22, confirms that the Council undertook a review of representations, and the summary of that is produced at Appendix B 1.2.3. As part of this review, consideration was given to the degree to which comments would affect the Council's assessment of the suitability of the site. Therefore, comments made through representations were addressed where the outcome would affect the Stage 3 assessment. The Council considers this approach to be proportionate. Where appropriate, updates or amendments were made to the Stage 2 assessments, and if those changes affected the overall suitability of the site at Stage 3, the assessment was updated accordingly. In terms of the deliverability assessment at Stages 4 and 6.4, paragraphs 4.39 and 4.81 explain that further deliverability information provided by site promoters through a survey was taken into account. That information was beyond that which was provided through the strategic land availability assessment, which had been undertaken earlier, and the call for sites process. And the paragraph 2.123 of the site selection report confirms the information received through representations to the plan, draft local plan, and updated information was taken into account. Okay, so moving on to where errors reported through Regulation 18 consultation checked. As advised at the Matter 4 hearing, the concerns raised by respondents, which included site promoters, were fed into the further site selection process. And that's explained through the site selection methodology and how the Tranche 1 sites were reviewed against representations. I can give you the paragraphs if that's helpful. And again, through the appendix, which I've just mentioned, B 1.2.3, has the list of those representations and the Council's response. With regard to the specific points raised during question, Council confirms those were checked, but they weren't determinant in the Council's decision not to allocate those sites in the local plan submission version. And in response to your question about the errors and comments reported in response to Tranche 2 sites, the Council is not proposing any amendments to the submitted plan in response to the representations received.
And does that apply also to potentially Tranche 1 sites, where in cases where, for example, they were proposed in the draft plan but were taken out, people have made supplementary responses on those, you don't feel, you have reviewed those, but you don't feel that any changes are necessary?
At this stage, the Council is not proposing to make any amendments.
Okay, thank you. And just going back to what you said in relation to the specific sites mentioned in my agenda about Marden Ash and the agricultural land, you said that those reported errors were checked, but it didn't alter your decision. So what did you do? Does that mean that the write-up for those particular sites remains wrong because it wasn't proportionate to change it, or did you didn't agree and didn't need to change it?
The write-up related to the work that had been undertaken prior to the local plan submission version going to full council. We have not rewritten the appendices following the Reg 1920 representations. So is there any response to the people who have reported errors, and whether you agreed or disagreed with those errors or not? We haven't made any specific reports on those matters. Sorry, so just to be clear about that, so you haven't responded. You've checked everything that was reported through the Regulation 18 consultation,
But unless it changed your conclusion, you haven't sort of written up.
We did write up after the Regulation 18 consultation stage. That's extensively written up in the appendix that I've referred to, and the reasons why we haven't changed.
So you did write it up regardless of whether it changed your views.
Absolutely.
So everything reported through Regulation 18 was written up regardless of whether it changed your view.
Yes.
Okay.
Just to clarify, that didn't necessarily mean the assessment was updated, but the reasons why we weren't changing was recorded.
It recorded in which document?
In the Appendix B 1.6.3. Is it? Sorry.
1.B 1.2.3, which is EB 805D.
Yeah. And that has a table listing all the representations received and the council's response.
Okay, so moving on then to the Regulation 1920 stage, there's no write-up of those comments?
The only write-up of those comments is a report that was taken to Cabinet in May 2018, which highlighted the main issues raised by not just site promoters, but other residents, parish town councils and so on in the district.
What's the reference for that Cabinet report? Sorry?
EB 115, page 12. Yeah,
that's okay.
EB 115A, actually. It's specifically Appendix 1 to that Cabinet report.
So I suppose just to push that point a bit, how can anyone sitting here know what you thought about the representations at that stage? Are we just hearing them here today? Have you formed a view? So when you say you're not proposing any, is that because you've made an informed decision that nothing needs to be changed, or are you leaving that to the examination process?
In essence, I think we are leaving it to the examination process as the appropriate place for people to bring forward further representations. We have obviously looked at them to make sure that we are satisfied that there aren't any significant changes or amendments that would be required as a result of those, but we haven't gone through another extensive site selection process. I mean, obviously we have also received, and as we all do, new sites. And we haven't, gone through a whole site selection process to look at those in relation to, what we have in the plan already.
Okay, thank you. Okay, if we move on now to the relationship between the site selection report and the SA and the HRA at stage 5.
Yes, section 3 of the site selection methodology sets out the evidence available for site selection and the relationship between the site selection work, sustainability appraisal and habitats regulations assessment. Specifically in respect of sustainability appraisal, paragraph 3.3, page A4, the Council identified 3 key stages during the plan-making process when reasonable alternatives should be subject to SA. So those key stages are site options, settlement-specific spatial distribution options, and district-wide spatial distribution options, which the site selection methodology confirmed was outside the scope of the site selection process. Taking those stages in turn, the first key stage, site options, was integrated within the site selection process. So the Sustainability Appraisal Report, which is EB 204, states in paragraph 6.27 that the site selection criteria used at stage 2 and stage 6.2 were developed to be in line with the SA framework. And the criteria used in site selection and their links to the SA framework are set out in Appendix 4 of the SA report. The next two stages in the SA process were carried out separately, but in parallel with the site selection process. So paragraph 6.37 to 6.40 in the Sustainability Appraisal Report explains that strategic settlement options were considered through the SA process, and the findings of that work, along with outlined reasons for the selection or rejection of the strategic options, are presented in Appendix 5 of the SA report. The findings of the work above, alongside wider evidence, informed the identification of district-wide spatial strategy options. Reasonable alternatives were then considered through the SA process, and this is explained within Part 1, Chapters 4 to 7 of the SA report. The sustainability appraisal of the settlement of the district-wide options informed the Council's selection of preferred sites, and paragraph 2.131 of the site selection report on page 45 in particular outlines how the findings of the technical assessment work, which included sustainability appraisal, was a consideration in recommending which sites to allocate in the local plan submission version. So turning to the Habitats Regulations Assessment, paragraph 3.4 of the site selection methodology on page A5 states that in relation to the Habitats Regulations Assessment, the process will need to consider the impact on European protected sites. So that included an initial assessment of sites being undertaken to understand the likelihood of any significant environmental effects arising from the potential allocation of individual sites, so that the impact on European protected sites can be taken into account as part of assessing the relative suitability of sites. In section 4, at paragraphs 4.46 and 4.91, that's pages A19 and A28 of the site selection methodology, it confirms the proposed site allocations will be subject to HRA as part of stage 5 and post-completion work following stage 8.4. So in applying the site selection process, the interaction with the Habitat Regulations Assessment was as follows. The site-specific suitability assessment included a criterion in relation to the impact on internationally protected sites. See page A29 of the site selection methodology. As Appendix B 1.4.1, page 191, that's EB 805E, explains, this assessment was undertaken by ACOM ecologists who also undertook the HRA work. Where appropriate, the impact on Epping Forest was taken into account when assessing the suitability of strategic options and the suitability of individual sites. The assessment results of the HRA of the draft local plan was one of the factors which influenced the technical assessment work which I've referred to earlier, which was undertaken in 2017. The result of the technical assessment was a material consideration assessing which sites to recommend for allocation in the local plan submission version. The HRA for the local plan submission version assessed the quantum and distribution of growth identified through the site selection process. No amendments were made to the proposed site allocations as a result of the 2017 HRA.
Thank you. Did you have anything more to say on that last bullet? Was that sort of wrapped up in your last answer? I have in my notes here that this was raised specifically in relation to the Jessel Green allocation and also WLAE8, Dowding Way. It's an employment allocation in relation to the transport impacts. It was raised in the statement. It was just, I don't know whether you want to address that now or whether that's something that will be addressed at, in May.
I think it's better left to May.
Okay. Okay. Thank you. We will stick to what I said. I'm conscious of the time, but I think the other 2 points are quite small. If we move on to the historic environment, can you just tell me what the status of the Statement of Common Ground is with Historic England?
Yes, the Statement of Common Ground with Historic England has now been signed both by Historic England and by the Council, and is available on the examination website as document ED24.
Thank you. 24. Thank you. And then the proposed modifications, I think, are largely relevant for other sessions, and I don't want to discuss them here. I think largely matters 8, 15 and 16. So I don't really want to take time discussing them from this agenda. I think there are a few concerning the introduction, vision and objectives, which I didn't have any concerns with, which could be added to the schedule from that session. And perhaps if you could ensure, and I'll try as well to ensure that those concerning SP4 and SP5 are raised under Matter 8 and that the others are raised in the relevant DM policies. The only question I wanted to address really on this agenda was what I understand from the Statement of Common Ground I'd read to be the sort of outstanding objection, was the absence of heritage impact assessments. And my question on this is there a significant risk that the effect of any allocation, either within the Garden Town or elsewhere, could not be avoided or mitigated to the extent it could not proceed in the form proposed? So is there any evidence or specific concerns beyond that the process was wrong, if you like, from Historic England or anyone else?
As we've set out in Appendix 2 to the Statement of Common Ground, the Council doesn't consider it's necessary to undertake heritage impact assessments of sites as part of the site selection process. However, an initial assessment was undertaken through the site selection process, and if you look at the evidence sources, in particular in relation to the strategic sites that Historic England have been concerned about, which is Latin Priory, Water Lane, east of Harlow and North Weald Bassett, those evidence sources are set out in the Appendix 3 of the Statement of Common Ground. The presence of heritage assets was taken into account when assessing the sites, and in particular when assessing the quantum of development that could be accommodated and therefore proposed for allocation on a particular site. The Council does consider there are sufficient provisions in the policies in the local plan submission version, particularly SP4 and DM7, including the proposed amendments, to ensure the conservation or enhancement of heritage assets in the district. And the Council considers the approach is proportionate and consistent with the requirements of national policy. We are proposing to require heritage impact assessments to be undertaken in preparing the strategic master plans for the garden community sites, and we're proposing to add that as a requirement to an amendment to policy SP4, and also to add to policy DM7 to require a heritage statement for any application that may affect heritage assets. And of course, for the larger sites, there will be a need to undertake environmental impact assessment at the planning application stage, and that will be an opportunity to ensure that heritage issues have been appropriately considered. In summary, the Council feel that the approach taken is proportionate and that we have taken adequate account of heritage assets when proposing the allocation and the quantum of development on sites.
Thank you. And when you've had your discussions with Historic England, obviously I've read their concerns about the process. Have they made any very specific objection to say that this asset cannot be preserved? Is there anything very specific to that point?
Not as specific as that. Obviously, they have raised concerns about the relationship of the sites to heritage assets. We feel they have been adequately taken into account.
Thank you. And then finally, before we open the discussion round the table, I just wanted to raise that there's a proposed modification to delete the sequential approach to the allocation of housing sites within policy SP2A. I don't know if the Council wanted to say anything about that, but if anybody else has any comments on that as we go round, that's something I'll take now. The Council have anything to say?
we're happy to take that out, bearing in mind that it's also set out in paragraph 2.66. We don't think it needs to be in policy as well.
Thank you. Thank you. Thank you. There was a lot to cover, so thank you everyone for listening. Okay, let's see who'd like to go first. Turn up your board if you have something to say. As I said, I'm only going to let you have one go initially. If we get to the end of the agenda and there's some spare time, then if there's anything you want to come back on or things you've forgotten to say, that's fine. But try to say everything you can at once. Thank you, Mr. Bell. We'll start with you.
Thank you, Ma'am. I have three points. First one's dealing with the role of assessment hierarchy in determining site allocations.
Yeah, sorry, if you...
Yeah, sure. This is set out in our matter statement, but overall we don't consider that the site selection methodology is robust, having regard to the limited role that the settlement hierarchy has played in determining site allocations. And as we heard in earlier hearing sessions, the council advised that this was simply a sense check. Our concern with this is that it's resulted in a plan which fails to locate growth in the most sustainable locations, and this is, for example, at odds with paragraph 17 of the NPPF, which aims to focus growth where it can make the fullest use of public transport, walking and cycling. Allocating growth at high order settlements such as Chigwell would clearly help achieve this fundamental aim of national policy, and the council's own evidence base suggests that deliverable sites that are not currently allocated exist in such sustainable locations. We therefore feel that the assessment process isn't justified for that reason alone. The second point then relates to the relative priority that the council has given to allocating sites on open space within settlements. In this context, I'd refer you to paragraph 74 of the NPPF that outlines that open space should not be built on unless it's either surplus to requirements, replaced by equivalent or better provision, or development is for sports and recreation. The council's evidence base relating to this is its open space strategy, that's EB 703. That identifies that the district as a whole suffers from open space deficits in many areas, and if I just take Chigwell again as an example, given that's where my client's site is located, that suffers from deficits in all categories but one. And therefore we feel in this context it's difficult to understand the priority that the council has given to allocating or developing on open space. If I then just take a specific example, allocation Chig R6, that's the Limes Farm site. Site selection report identifies that there may be a short-term reduction in amenity green space, but the master plan will seek to re-provide existing provision. Now the difficulty here is that there's no evidence to suggest how this can be achieved when you need to deliver 100 dwellings on the site. The policy wording doesn't require re-provision, nor does the site-specific requirements in Appendix 6. So on that basis, we sort of struggle to conclude how that site, or indeed others, could be form part of a robust assessment, as effectively it conflicts with the council's own test to preserve open space, and indeed the test of national policy. The final point is more of a question, and that's in respect of where, it's in respect of Chig R4, and I've been reviewing the council's site selection report, in particular the results of identifying sites for allocation, that's EB 805P, which in the process table that council helpfully provided, that's the final stage. And when I look at that, I can't find any reference to that site, despite it being allocated. So it'll be useful to understand from the council where the evidence is for that site. Thank you.
Mr. Kosky.
Thank you, Ma'am. I agree with the gentleman on my left. I share the same concerns that we heard from the council with their pre-prepared statements, how the methodology was all very sound, etc. And you know, we can go through this very prescriptively, but I don't think that really serves any purpose. Having attended the earlier sessions here, I think the problem that there is with this site selection methodology, and it affects our site that we're promoting, is that there's just this contagion running through the whole process, which I've set out in my evidence. We know what the council's position is in terms of when they submitted their plan, that they wanted to reduce exposure to higher housing numbers. That philosophy has filtered all the way through the site selection process. So you get these inequities whereby a site on the east of Waltham Abbey is completely rejected because all of east of Waltham Abbey is not consistent with the spatial strategy, the preferred spatial strategy. And as I set out in my evidence, the site itself was not assessed individually. And we've heard evidence this morning from the council that all the sites were assessed individually, and there was a sort of an exercise of remediation to look at a finer grain. And we did touch on this quite a lot in earlier sessions about the finer grain of site assessment. And I know there's lots of people who want to speak this morning, so I'm not going to labour the point. But in my evidence of matter 5, at Appendix 1, I show the actual site that's promoted, which bears no relationship whatsoever to the site that the council assessed. If the council assessed a larger site and rejected it by reason of it not being compatible with a preferred spatial strategy, then logic dictates that any site within that larger parcel would equally be inconsistent with this predetermined spatial strategy.
Sorry, can I just clarify there? Because again, I maybe haven't. Are you talking about how it was assessed in terms of greenbelt harm when you're talking about the larger parcels, or full stop? I
think full stop. Full stop. In my evidence, Ma'am, I set out at 2.14 and 2.15 evidence of incorrect scale of assessment. So when you assess a larger site, a much larger site than the site actually promoted, then of course it's going to have additional flooding issues that the promoted site might not have. It's going to have wider impacts, wider environmental impacts, and be less deliverable. And of course, the site that's actually promoted, and I think I speak for a lot of people here with emission sites, the site that was actually promoted bears no relation to the site that was assessed. And the site that was assessed was rejected in principle, as well as all the site-specific issues which you could mitigate with a smaller site. And as I said at the beginning of this, the contagion is that all of this was predetermined. And it says so at the beginning of the plan, that the plan was submitted to avoid the risk of higher numbers. So the sustainability appraisal has to follow suit. The spatial strategy that is derived from that follows suit. And a site selection methodology cannot be objective and fair and reasonable if it has a predetermined outcome to be consistent with a predetermined strategy.
Sorry to interrupt you again, Mr. Koski, but I do want to understand this point. At what stage was your site sifted out?
It was sifted out very, very early, at the initial stages. And the council said this morning that they then invited promoters of sites to come back and have a chat. Well, the feedback I've had from my client was it was a 20-minute speed dating type of thing. There's no other analogy I can use, whereby the issues were sort of pretty much run through and dismissed. I can see nothing in the evidence base that shows that the site that we have at Appendix 1 in our matter statement was ever assessed on its own merits. I see nothing in the evidence base to show that.
Can I just come back to the council quickly? So are you familiar with the site or the circumstances that are being described? Because this was the essence of my question that was misunderstood earlier. So I do want to be clear about it. I mean, my understanding from my reading a little while ago now of the site selection methodology was that some sites were sifted out very early as being part of a major policy constraint. Are the sites that we're hearing about as being sort of part of a wider agglomeration, are they those types of sites that were sifted out early? Could you explain that for me? Thank you.
So just to clarify, for stage 1 and stage 6.1, it was an individual site assessment against the 6 criteria that are set out in table 1 of the site selection process. And for clarity, none of those relate to Greenbelt. So one assessment buffer zones, one is sites entirely within flood zone 3B, one is sites in internationally designated sites of importance. One is sites fully within county-owned or managed wildlife sites or council-owned or managed local nature reserves. Another is sites within the City of London Corporation Epping Forest, which is different to the special area of conservation and its buffer land. And then the final one is if they were sites are fully located within the health and safety executive consultation zones in a zone. And the findings of that, as I put in the diagram, are set out in EB 805AJ. What I believe Mr. Koski is referring to is stage 3 or 6.3 of the site selection methodology, of which the first step was to create strategic options around the settlements. And in doing that, the council drew on a range of evidence, and the justification for the strategic options being designated more or less suitable is set out in Appendix 1.5.2, which you think by now I know the letters, which is EB 805I. Greenbelt was one of the considerations taken into account, as well as a range of other factors, including flood risk, landscape sensitivity, etc. Also, just to confirm, at stage 2, as I said at the beginning of the hearing session, all sites are subject to a site-specific suitability assessment that went through stage 1. So if you take it chronologically, if you got through stage 1, then you're subject to stage 2, which was the site-specific criteria, suitability assessment criteria. And then if you...
And that was an individual?
Yeah, that was individual. And then at stage 3, then the first step was to identify these strategic options and whether they were more or less suitable. Sites which were in less suitable strategic options were filtered out at that stage. And then sites which were in more suitable strategic options were then looked at individually to determine their suitability. And in doing that, the council drew on the stage 2 suitability, site-specific suitability assessment.
So going back to Mr. Koski's site then, if he's concerned that it was dealt with on a wider scale, is it the case that his was filtered out at that stage 3?
That's correct.
Okay, so it would have been assessed individually until that point, but then would have been filtered out at stage 3 as part of a wider area that was less suitable?
Yeah.
Okay. Do you agree with that, Mr. Koski?
That's my point entirely. It was filtered out as being part of an area that was considered not suitable in principle.
Okay.
The council have the matter statement. They have the Appendix 1. I would be very grateful if they could draw... I've not been able to find it. I'd be very grateful if the council could draw my attention to the evidence of where they've assessed this site individually. And I'm sure I'm not alone here amongst other promoters. I did have one other point, Ma'am, on the heritage issue. Turning to heritage, I find it absolutely incredulous that the council can be so matter-of-fact and blasé regarding the lack of heritage impact assessments. Those of us who've been practicing a very long time can remember back in the day when ecology was treated the same way, that we'll deal with it through the application or we'll deal with it by condition. And case law obviously determined that you need to have all the information before you can make judgments like that. So the unresolved objections in the Statement of Common Ground from they are very, very specific and relate to the strategic sites. And if you look at Historic England, their sort of best practice guidance, what they do is they say you should go through a 5-step process. So very, very quickly you identify the asset affected, you assess the degree to which the settings contribute to the asset's significance or allow significance to be appreciated. Step 3, you assess the effects of the proposed development on that significance. Step 4, you explore ways to maximise, enhance and minimise harm. And step 5, you make your decision and your considerations and go forward from there. But it seems to me that the council have only really undertaken step 1 of that process and nothing else. They've left everything downstream to the application stage. So if we just look over the horizon at a future application and the heritage impact statement is produced, the environmental impact statement is produced, and we heard from Mr. Hill at one of the sessions recently, he wanted to increase densities on his site. I think you recall that, Ma'am. So how can you make judgments like that on capacity when you haven't assessed the significance of the heritage assets that need to be protected? So in the real world, there'll be a solution. There always is a solution, but it may involve a safeguarding area beyond what's envisaged. So to maintain the densities, maintain the capacity of the site, you'd have to increase densities. That has an impact on listed buildings and heritage assets. The reality is the council cannot rely upon the numbers they allocate to the strategic sites where heritage impact assessments have not been undertaken. And that could result in reductions of 5 or 10%, but on a strategic site, that's going to be a lot of dwellings and then going to need to be reallocated somewhere else. Thank you.
Thank you. Sorry, who's that? I can't see your name. Can you turn the next gentleman along? Mr. Hawes, thank you.
Thank you, ma'am. Our concerns are with our site, which is Loughton R2. My company, Loughton Self-Drive, exists within part of that site. I have highlighted on the map, if that would help you at all, ma'am. I have highlighted our area within that site, if that would help you at all. And there's also photos of the business in situ as well. Our argument is that the council's site selection was certainly not positively prepared and breaches the national NPPF guidelines. There's no mention of the business. Indeed, they refer to the site purely as a car park. And we'd argue that goes against the NPF framework guidelines regarding certainly having the right information crucial to decision making, paragraph 192. There was no early or meaningful engagement, collaboration with ourselves, as there should have been under paragraph 155. It says collaboration with business is essential. And there's been no engagement or any effort to incorporate ourselves in existing proposed residential development, which again the NPPF refers to in paragraph 21. And also plans should also guard against the unnecessary loss of valued facilities and services, which I'd argue after 25 years we'd like to think we are one of them. We have made other points within our representation that you have. And the last point I'd like to make is that the council's own guidelines for that site, due to any lack of many meaningful parking proposed at the site, they propose a car club or car sharing scheme, which unbelievably is exactly what we do. And we run all Euro 6 eco-friendly, low and ultra-low emission vehicles. And I think we would have been perfectly poised to liaise with the council to exist within their plans. I understand, I heard earlier today that the council acknowledges they made no response to Section 19 representations, and this merely just demonstrates the continued failure to operate within the NPF guidelines with regard to any collaboration. That's my points, ma'am. Thank you.
Thank you. So just so that I can be very clear about what your concern is, you're saying your site is, your business is part of a wider site that's been allocated for residential development. Are you saying that
That's correct, ma'am.
your part of the site, are you saying it's not available for residential development?
Unfortunately, we don't own the property. We're leased it from Transport for London, who the council have been in negotiations with. I'm merely arguing that the total dismissal of us as a business entity there just isn't correct.
Okay, thank you.
Thank you.
Thank you, Mr. Hawes. Mr. Dodkins.
Thank you, Ma'am. I can be very brief because Mr. Koski made many of the points that I would like to make. That's all right. Pleasure. I think, our site at North East Ongar, London Road, was sifted out also at a very early stage, as I said last time, principally on Greenbelt grounds. It scored very adversely against on the Greenbelt criteria. The Greenbelt study stage, Purpose 4 was given a great deal of weight and was considered to be very strong. When it came down to the individual site assessment, our site was fairly neutral from the heritage point of view, yet still scored very highly from the Greenbelt point of view, despite the fact that other Greenbelt purposes were not scored highly at the initial stage. So I think there was quite a degree of, I think Mr. Koski used the word contagion, that sort of permeated into the individual site assessments. In terms of heritage itself, you've obviously mentioned the statement of common ground. I'd also point out the statement that's also been submitted by Historic England to the examination. In particular, it points out that heritage impact assessments do not form part of the evidence base for the local plan, but they do emphasise these are essential to test the suitability of sites, and I'd endorse that wholeheartedly.
Thank you. Thank you, Mr. Duckins. Mr. Simmons.
Madam, we don't necessarily take issue with the site selection methodology, nor indeed the overall work undertaken by ARUPS. Our concern, Madam, is with the decision-making process. And by way of example, in the case of my client site, Madam, which, as you're aware, is the land to the north of Abridge Road, the old Foresters site at Thaden Boys, it would appear that it was the member workshop, as opposed to the site selection methodology or advice from professionals or consultants, that led to the site's housing allocation being removed at the Regulation 19 stage. In other words, Madam, we have a concern that the decision with regard to our site was made on non-planning and non-technical grounds. Indeed, it would appear to us that with regard to our site, the site selection methodology was completely ignored. If a proper dialogue had taken place, for example, at the workshop stage, or indeed if Appendix B had been made available at an earlier stage, the apparent reason for the deselection or the deallocation of my client's site could easily have been resolved. This being the provision, or the requirement rather, to make provision for SANG in response to the comments made by the conservators of Epping Forest. And Madam, it is on this point, responding to comments made by the conservators and cross-referencing to your question on the effects of the Epping Forest special area of consideration, that we say, Madam, that there is inconsistency in the Council's decision-making process. And notably, Madam, the Conservators made the same point with regard to my client site and also in relation to the Jessel Green site. And Madam, as I'm sure you are aware, in response to the Conservators, the Council removed the allocation on my client site, yet despite much opposition from the public, promoted the Jessel Green site for allocation. So, Madam, we have concerns with the development making process. We have concerns with the inconsistency of the Council's approach. And, Madam, just to check, will speakers get an opportunity to address, I think it's your bullet point 4, and notably the last sentence, why could more sites not be allocated? We'll have a separate slot to deal with that.
I'm going to do that next.
In which case, Madam, my further points will be addressed during that part of the agenda.
Thank you.
Thank you.
Mr. Ireland.
Thank you, Madam. My client's site adjoins the Loughton-Debden urban area, but was screened out as in stage 1 of the site selection process, and the reasons set out for that are that the site was judged to be located outside of settlement buffer zones. That is set out, and the reference for it is its site SR0492. SR0492, and that's Appendix B1.3, which shows the results of that Stage 1 process. Now, those buffer zones that have been used in the site selection process are not clearly mapped and delineated. It's quite difficult to understand what they are. The only reference that we can find to how settlement buffer zones are set out is within the Stage 2 Greenbelt study in Table 2.3, which talked about a settlement buffer for Loughton Debden, which extends 2 kilometres from, effectively from the town's boundaries. And our site would clearly fall within that area. So it is unclear why it has been screened out on that basis. Now, if we then look at the site selection methodology and some of the plans in there, it does in fact appear that the land on the eastern side of Loughton and Debden has been assessed in relation in terms of its relationship to Chigwell rather than Loughton Debden. And so a site which adjoins the Loughton Debden urban area is assessed as outside of the Chigwells settlement buffer zone and screened out on that basis. Now, it's unclear why that's the case. It does appear to us that, in fact, the site assessment process has been constrained to parish boundaries in that respect. And so while land on the eastern side of Loughton Debden lies in Chigwell parish, it has been assessed in respect of the growth of Chigwell, which we don't consider is a sound approach. Thank you.
Thank you. Mr. Asprey.
Thank you, ma'am. I want to endorse what Mr. Arlen, Mr. Kosky and Mr. Simmons have already said, because I'm making similar points but slightly different. I think the concern we have, and it's a theme that's come across throughout this examination, is that the process is superficially objective, superficially attractive. But the glue that needs to hold this process together is the application and interpretation of the evidence and the decision-making that flows from that. And this is where we feel there is a lack of an evidence base for it. And without that clear, I've called it a cascade in my statement, but that clear cascade of decision-making and justification. And the problem is that if the evidence, the site selection process is applied in the way it has been, which tends to be in a circular and self-referencing way, so that you constantly refer back to earlier decisions. Now, if those decisions are fundamentally flawed, or they're contaminated by bias or political influence, then the whole process, the whole house of cards, cannot be sustained. It collapses. And this is the problem. I still have reservations, ma'am, about the land preference hierarchy and how that has been used to inform the process. And it seems to me that there's been clear predetermination here. The council settled on what it wanted was a strategy and then used the evidence base to justify that. I take an example as well in relation to buffer zones. You've been referenced today, ma'am, the county council assessments, one of which EB 500F. I don't want to take you to that now, ma'am, but other than to say that we looked at that, and what is clear from that, and if I'm looking at table 1.4, which looks at the Epping Forest South local plan sites, that our site in particular, but other Chigwell sites, have been treated as part of larger areas. So the county council comes to a conclusion where you see a row of reds or ambers, when on any objective assessment of the site as we have promoted it, you should have all greens with some ambers. Now that's because the county council took the site that the district council gave it and assessed it so that most of it fell outside a buffer zone. And this is the way in which previous decisions, previous assumptions, previous predetermination has infected the process all the way through, and so that it's fundamentally flawed. I've cited some other examples of mistakes and inconsistencies in my statement, Mum. I don't want to go, as you don't want to, go to individual sites. But this is the problem.
Is Miss Williams? Or?
Thank you, Madam.
Oh, sorry.
David Mosley, Persimmon Homes. Persimmon's statement focuses upon the rationale soundness for the exclusion of sites between Regulation 18 in October 2016 and Regulation 19 in December 2017. I share a lot of matters of common ground with Mr Simmons in relation to the general soundness of the methodology, however the lack of transparency when it comes to the decisions, and particularly the role of the member workshop to exclude certain sites. In particular, Epping as a settlement was allocated for 1,640 homes in the Regulation 18 stage. However, by Regulation 19, that had significantly reduced by 20% to 1,305 homes. There's clearly a significant role for the member workshop in excluding at least 3 sites within Epping, including Persimmon's freehold land at Thaden Place, Epping, which have been identified at Regulation 18 stage. In terms of some of the statements made, I believe they lack sufficient evidence in relation to the consideration of sites that were deemed to be more preferable, and in particular comments in relation to the cumulatively providing the desired growth, particularly in view of the fact that the plan as a whole wouldn't meet a 5-year housing land supply within the first 5 years of the plan. In addition, weight was clearly given to a neighbourhood plan at that point in time that didn't exist and was clearly at an early point of gestation. So I think I share many of the concerns of Mr Simmons in relation to the transparency of the member workshop and the non-planning and non-technical grounds that were cited in relation to the exclusion of certain sites and the inclusion of further sites. And as a whole, it's left the settlement short by 20% in terms of housing provision from what could have clearly been identified as additional inclusions within the plan.
Thank you. Ms Williams?
Thanks. I think I share a lot of what Mr Simmons has said. My client's land is also land north of Abridge Road at Thaden Boys, site reference 026C, which was included at Regulation 18 stage. The council cited the fact that they engaged with promoters who didn't get an allocation at the Reg 18 stage. What they then didn't do was engage with promoters who had sites removed after that stage to see whether any issues could be addressed. And in particular, in relation to the Conservatives' comments, which was the prime reason for removing the allocations at Thaden Boys, we submitted evidence to the council to demonstrate that we could incorporate on-site SANGs, which would basically alleviate all of the Conservatives' concerns. At no point did the council try to engage with us to see to determine whether the site was still deliverable. They just concluded that the site was not deliverable. I think in relation to the process, the fact that, I share Mr Simmons' comments in relation to the transparency of those workshops and comments like in the site selection conclusion in relation to the site saying that they were less preferred by the community. I mean, there's no evidence, no substantive evidence to demonstrate that. And again, there was no engagement with promoters to see whether any issues could be addressed. And also, yes, in relation to the Jessel Green site, the Conservatives' comments say that they are of the view that the proposed loss of green space at Borders Lane and Jessel Green, the latter in particular, if lost, would place considerable pressure on the nearby forest. And whereas in relation to Thaden Boys, all they say is that despite it being less than 400 units, they would request that a SANG is included. So there is a significant lack of consistency and transparency as to how the process has been applied. Thanks.
Thank you. Mr. Surtees.
Thank you, ma'am. We've been promoting land at Luxborough Lane, Chigwell for Higgins Homes probably since the early stages of the plan-making process. I date that back probably to about early 2013. And in July 2013, we submitted a document to the council as part of a process that we hoped would begin in order to demonstrate the suitability of our site for houses. And at that time, and consistently throughout the process, we identified that this site could deliver between 45 and 90 dwellings. I mentioned that because, and a number of other people have already made this point, that the characteristic of all our responses to each stage of the plan-making process has been that the council has never fully engaged with actually dealing with our site. It's always formed part of the consideration of a wider area. Without repeating our statement, we date that back probably to 2010 with the Settlement Edge Landscape Strategy Sensitivity Study, which identified a swathe of land along the entirety of Chigwell. And effectively, that has defined a process that has meant that the council have never really engaged with looking at options along the western side of Chigwell. More recently, we refer to the Greenbelt review process. This has been embedded into the site selection methodology and into that report. And whilst I've heard from Arup that they say that they've looked individually at sites, when you look actually at the evidence, and we're just looking here at the site performer for the parcel within which our site is identified, and that's parcel 36.2, it combines not only our site with a parcel and then with at least 4 other parcels on the western side of Chigwell and jumping over the M11. And therefore there's a conclusion starting to build that our site is unsuitable development because it's in a wider area that's unsuitable. We've never been able to actually get the chance, apart from what Mr. Koski, I believe, referred to as speed dating. We had 20 minutes with my client who's here to make our case, and we were effectively told that the western side of Chigwell was not suitable for development. If development was likely to happen, it would be either on the other side of Chigwell or elsewhere. And just to confirm the point about our contention that our site has not been assessed alone, within the notes that we received following our November meeting, and we did append it, the conclusion and the reason why we were sifted out clearly states this site is part of a strategic option which was judged to be less favourable. I think our message has always been if we could be considered actually on our own merits, and we are within a location where the council has identified another site for allocation, that we would probably get a more favourable consideration. And just to take it to a more strategic level, we have to remember that this site is in a very sustainable location. It's past the settlement buffer zone test. It's near a tube station, which we now know has capacity. It's even on a bus route that's close to Ilford, which has got the Elizabeth line. And plus, I think Mr. Bolton mentioned at a previous session, we are probably the closest settlement to London and all the facilities and services and sustainability that offers. So I think our main point is that we would prefer and would like to finally have our proper meeting to actually engage with the council and to identify the benefits for the allocation of our site. Thank you.
Mr. Shaw.
Yeah, so I think in terms of the case that Mr. Ashbury made, I fully support that, and it encapsulates what my position is in terms of how the process has been run. I want to talk about the application of the methodology and the lack of robustness of the evidence base, and also the quality and effectiveness of the QA process, because that's where I've got some examples where it really stands out that these haven't been followed effectively and evidence hasn't been robust. So if we take Limes Farm Green, that's been assessed as 100% urban brownfield. But in the assessment itself, within the same statement, it talks about how there'll be a loss of amenity green space. So there's an embedded inconsistency within the evidence base for Limes Farm Green. When I looked to my site, during the assessment there were 5 similar sites. They're all houses with gardens. They're all within a sustainable location, and they're all within an area where there's flatted development. 4 of them were assessed as urban brownfield, 100%, whereas my site was classified as urban open space, and it's a home. So there's some quite stark inconsistencies within the assessment, and that has had that cascade effect that many of the participants here have already spoken about. So, taking some of the points that the council made earlier around in terms of collaboration, it being a very collaborative process, the only time I became engaged or knew about the site selection methodology was in publication in March 2019. No invitation at any stage to be involved in workshops. So from my perspective, I didn't feel it was a collaborative process. Within the workshops themselves, council noted that the QA process was local councillors giving their opinions and checking for factual accuracy. Now there's a clear asymmetry of information and knowledge between site owners and local councillors, and it doesn't make sense to me why you wouldn't involve people who do have stronger knowledge of sites in that process at that early stage, so that issues can be corrected up front. And finally, the council noted the lack of the non-correction of factual errors. So my understanding is that the local plan needs to be sound. It needs to be based on a up-to-date evidence base. So in my case, I've gone to appeal for my site. The planning inspector itself has found and actually specifically called out the lack of evidence for some of the assertions that the council was making that formed grounds for refusal. So I just asked the question, how can the plan be sound if the council isn't prepared to take on board up-to-date evidence and clarify errors that were made? Thank you.
Thank you. Mr. Churchill.
Thank you, Ma'am. I'm here representing Countryside Properties with reference to site SR0049, and obviously addressing you on the matters of site selection. And I'll attempt to keep it brief. The matters or the concerns that we have with the process are twofold. One being that the site was dismissed without good reason, and obviously you have our representations in the form of representations of the relevant stages of the plan. We also have our hearing statement within which we set out the details of that, so I won't rehash that. But it's relevant to note that the site was proposed as an allocation. It fell out at a late stage, and as we've heard, there was no site omission meeting that happened at that point. It was merely the member workshop matter. And we've obviously set out our concerns with that process. So that's concern number one. Concern number two are the errors in the approach to the assessment. Again, we set out the matters in our hearing statement, but it's worth just running through those just to contextualise. The site assessment confirmed there were no identified constraints to the site coming forward. There were no identified restrictions that would prevent it coming forward. At each stage of the assessment, it was considered suitable. It fell at stage 4 for no good reason, and the reference document, or the point at which it fell, was EB805P. I'll come back to that a little bit later on. It's within a parcel that performs weekly in the Greenbelt. And moreover, it plays a very limited role in the Greenbelt. It's accepted as delivering a range of potential benefits, including affordable housing and a contribution to the vitality and viability of local services and the primary school. And it was assessed as being a highly sustainable development site. There are factual errors in the Stage 2 suitability assessment, but those errors to a degree are mitigated in the site because it passed that stage anyway. But despite all this, EB 805P stated that on balance it was considered an alternative site was more suitable and would provide for a scale of growth that's more appropriate to the settlement. Yet, one, the alternative is no better in Greenbelt terms, it doesn't perform better. Two, the alternative will not deliver affordable housing, as site SR0049 would. And three, the reason for its on balance falling out of the plan was in relation to the scale of growth, and our representations back through the stages of the plan have highlighted the fallacy and the inconsistency of the approach regarding scale of growth. Notably, similar same size settlements within the settlement hierarchy in the same tier, that them being Nasing, Roydon, Shearing and Thornwood, had an average of 110 dwellings per settlement allocated to them, yet Firefield sees only 14. It's worth also setting the range there between 62 houses and 172. So our concern is throughout that process there's logic absent, consistency absent, and as a consequence there are errors in the eventual assessment process. And for that reason, obviously we put forward the site should be included.
Thank you. Mr. McSweeney.
By way of background, I'm representing London Square site in Chigwell, which is reference SR0601. And we promoted the site as part of the 2016 call for sites, so I believe it's a tranche 1 site, and we had an allocation for 30 residential units and removal for the Greenbelt at the Reg 18 stage, and then allocation was removed and Greenbelt status reinstated at the Regulation 19 stage. And so we were invited, in terms of the officer and member workshops, we were invited to attend developer forum meetings on behalf of London Square, of which we attended 4 meetings in 2016 and 2017. None of these meetings were preferred strategic options regarding specific sites discussed, and we're not invited to participate in any meetings following these forums. These were kind of general updates on the local plan process, and many of the issues in terms of site selection have come about with sites being allocated at the Regulation 18 stage and then the draft allocations being removed at the 19 stage. In terms of individual site assessments, whilst individual site assessments may have taken place, it does not appear that individual sites were visited as part of the assessment process, which is an important point in terms of errors that have come about in terms of our site that we're interested in. We submitted draft representations at every stage of the local plan consultation, and generally the mistakes that have been identified in the Appendix B could have been avoided should had all of our previous representations been considered in detail. One point which I'm not sure has been made yet is that in terms of errors at Regulation 18 stage, these may have not been obvious to parties due to draft allocations, and then they may have been more obvious later when allocations were removed. So at the Regulation 19 stage, in terms of SR0601, we identified 4 fairly large mistakes in terms of the site assessment being categorised as high quality agricultural land when it's covered in hard standing, in terms of it being 86% of the site within the health and safety executive's inner and middle zone, which isn't correct. 2 tree preservation orders, which when there's no trees on the site, and that the site appears to be being developed for dwellings when in fact the site isn't being developed for anything. So my point being that if a site visit had taken place, these errors could have been avoided. So given the representations which have already been heard in respect of housing land supply and greenbelt parcels, we consider that the errors reported in response to the Regulation 19 stage demonstrate that the site's suitable, available and deliverable in the short term and could contribute residential units to assist with meeting the district's housing land supply.
Mr. Taylor.
Good morning, Madam. The primary submission I'm making on behalf of my clients is that the site selection process is not robust, it is not justified, it is not transparent, and it is not sound. In making that, my clients have raised three primary points in relation to its site, the former Northfield Golf Course. The first of those relates to the adopted parcel size for the assessment methodology in relation to the Greenbelt. These 3 points all lead to key points as to the application of the process, the decision making that's been undertaken. My client site straddles the A414. Effectively, at the early stage, it was divided into two parcels for assessment. At stage 2, the council merged the north and south parcels into one. That led to appraisal on the basis of a wider site as opposed to two separate sites for Greenbelt purposes. My clients then instructed AMEC Foster Wheeler to review the approach to Greenbelt of the separate parcels, and that review you have in the hearing statement that's been provided in Appendix 1. The review identifies a differential between the north and southern parcels in Greenbelt terms. There has, as far as we're aware, been no assessment by the council that breaks the two parcels which are divided by the A414, obviously a defensible boundary, separately. And so our site has been scored and judged in Greenbelt terms on the basis of an assessment of a wider site as opposed to breaking it down. We've never seen any justification of the wider approach that's been adopted. We've had no response to that point whatsoever. So there's been a complete failure to justify the size of the plot that's been assessed and a failure to consider subdivision, which has significant process and methodological failures in my submission. That's the first point. In relation to flood risk, second point, my client's site scored a negative in the scoring system on the basis that the site includes land in flood zone 3A. In fact, 70% of my client's site lies within flood zone 1. And indeed, my client's made an application for planning permission which demonstrates that all the housing proposed would be in flood zone 1. We've not had any response to that particular issue as to why we've scored a negative. And it's important, particularly in the context of other sites. For example, Taylor's Yard in Ongar. I have to say that Taylor's no relation to me. But that site, it stated that 56% of the site is in flood zone 2, of which 10% and 18% are in both flood zone 3A and flood zone 3B. And yet that site scored a positive. So we're sitting here wondering why on earth that site gets a positive, but we get a score 2 notches below, when actually 70% of our site is in flood zone 1. There's a lack of consistency here and a lack of clarity in the way in which the process has been applied in relation to the flood risk, which leads to a lack of justification. The last point that my clients raised is in relation to the consideration of BMV. My client's site scored a double negative because of the loss of best and most versatile land. But it's been a golf course for 20 years. It's not in agricultural use. Indeed, rather it's made ground, as the council is aware, because it's set out in the environmental statement that accompanies the current planning application. allocation. That is a serious error, and an error that affects the scoring of the site in a considerable way. So where do we see a response to these points? Well, I've looked at EB 115A this morning, as we were referred to earlier. That is so vague, it doesn't inform members as to the nature of the issues that have been raised in relation to individual sites, and certainly doesn't address the points that I've just drawn to your attention, Madam. And so we're at this examination, we don't know what of those points I've just raised the Council accept, which they disagree with, or why they disagree if they do. There's been a complete absence of any reassessment of either individual sites, a rescoring of individual sites, or indeed an absence of a rescoring of all the sites in the round, which is what has to be done to justify site selection. On that basis, we sit here unable to engage with the Council on these points because we do not know what the Council is actually saying in response to our objections. That is then the position. There is no evidence and no justification that establishes that no amendments need to be made to the process. It's not a justified process, and it's not a fair process. That is particularly the case in relation to my clients who have been denied the opportunity to discuss their site and why it hasn't been proposed for allocation and what the reaction is to these clear points that have been raised. There's been no meeting. And indeed, you know you're in trouble where, like my clients, you're not even invited to a speed dating exercise in November 2016. We weren't invited. There's been no meeting. This is our only available process to engage, and we find ourselves here with nothing to engage with. Matt, thank you very much for your time.
Thank you, Solid.
Thank you. We concur with many of the points made around the table that the site selection process has been fundamentally flawed. Just want to pick up on a few specific points in relation to our site at Temple Farm in Roydon. I'd like to draw your attention to page 62 of the settlement hierarchy technical paper, which refers to strong representations having been received from local ward councillors and the parish council on the position of Roydon in the settlement hierarchy. It is the only settlement within the technical paper which refers to representations from councillors or parish council within the qualitative analysis of the settlement. The result being that despite containing the necessary number of services and facilities to be considered by the technical paper as a large village, it was downgraded to a small village. We would obviously question how and why such representations were considered relevant to the qualitative analysis process, and seemingly.
Sorry, Ms. Orwell, I don't want you to be the only one that I stopped, but we did hear specifically about the demotion of Roydon in the last session, so I don't want to hear about that again, unless it's in a different context.
Well, the context being that in the case of Roydon, these representations and the conclusion that followed clearly influenced the objective of the Stage 3 assessment to identify sites which best meet the Council's preferred growth strategy. And like others around the table, we consider that the preferred strategy was predetermined with sites then chosen to fit within it. I'd also like to draw attention to paragraph 2.6 of the Site Selection Report 2018, which states the approach was premised on the basis of the best fit sites for a settlement, not best fit sites for the district. It's not clear exactly what that means, but it does infer what is best for the district, such as sustainable sites close to transport hubs consistent with the framework, comes second to what the settlement thinks is best, which has clearly been the case for Roydon, where representations have been considered and a conclusion reached in terms of its status in the settlement hierarchy. Secondly, I'd like to point out that our site, Temple Farm, was considered part of a larger parcel, despite submission of information that it was not. The site was assessed in both the Strategic Land Availability Assessment and Report on Site Selection 2016, based on an area that was submitted to a historic 2008 call for sites, and not up-to-date information which we submitted to the Landowner and Promoter Survey in 2016. This was prior to the publication of both of those reports and following written confirmation from the Council that the site had been assessed on the new updated information, which transpired to be untrue. This has been acknowledged by the Council and detailed in our representations, but the site selection report in 2018 wrongly refers to it being reconsidered at stage 3 in 2017 as having the potential to contribute to a 5-year housing land supply. This wasn't the case. It was actually to readdress the error that had been made in assessing and discounting a larger site area. Thirdly, in terms of information that we submitted and whether that had been taken into account, there is no evidence to suggest that has happened. Specifically, pre-application advice from Essex County Council in relation to highways, where the minutes concluded there was no known highway or junction capacity issues in Roydon, yet the site was still given a double negative in the site selection report on the basis of moderate peak time congestion. And also there was no evidence that the master planning work, which formed part of pre-application discussions and representations to the plan, has been taken into account in terms of landscape, accessibility and recreational benefits, the ability of the master plan, which is fully aligned with the statutory functions of the Lee Valley Regional Park Authority, to meet the objectives of the park development framework and thematic policies, which identify the need to improve the landscape and encourage investment, have not been taken into consideration. As discussed in matter 2, I believe the Council has confirmed that they've not been using the up-to-date information and this will be reconsidered. But we don't think it is robust, especially on land that contributes little to the Greenbelt and located adjacent to a train station, to assume that the presence in the Lee Valley Regional Park equates to harm with no accompanying evidence. Finally, in respect of the sequential approach to site allocation, in policy SB2A, we would just concur with Mr Bell's comments and others around the table in relation to prioritising open space and the conflicts with Power 74 in the MPPF, and also there being no reference to transport hubs in the sequential approach, which is in conflict with the plan's own objectives and the framework. Ms Newton.
Thank you. I just wanted to address your question about the absence of heritage impact assessments at the site selection stage. As the Council have pointed out, work was carried out by the Council, described as an initial assessment of heritage impacts in the process of allocating sites. Now, that wasn't a full heritage impact assessment in every case, but I think the key point is that it was sufficient to conclude that the effects on heritage assets were not at a level or a magnitude that could not be avoided or mitigated. And I think that's the test, really, is making that judgment and whether there's a sufficient basis for that judgment. I think it's recognised that a full HIA wasn't carried out. And Historic England here are making a procedural point, and Mr Koski has reminded us of best practice principles, but would just point out that Historic England have not cited any specific concerns about heritage impacts in relation to proposed allocations. So the work was proportionate, as the Council have suggested, and fit for purpose. It's also worth noting the Council has done some further work to explain the basis for its conclusions, and that's set out in Appendix 3 of the Statement of Common Ground between Historic England and the Council. It's also important to recognise that the site promoters have often done detailed work on heritage impacts that augments the Council's evidence base. Now, that's in the case, that work has been done in the case of Latin Priory, we were invited to submit detailed technical assessments to AECOM as part of their strategic site selection work. And that was part of an ongoing process of constructive engagement and what was quite an interactive process with the council, in part through the developer forum process. One of those submissions that we made to AECOM was a first assessment made over 10 years ago, actually, on heritage impacts, carried out in discussions with what's now known as Historic England, and with Essex County Council. More recently, a desk-based heritage assessment was carried out by Orion Heritage in October last year, and that was commissioned to inform the strategic master plan process and the subsequent outline planning application that will follow that. The scope of that assessment was agreed with the historic environment consultants at Place Services, who were acting for Essex County Council. And that assessment was of the 2 scheduled ancient monuments at Latin Priory, one of which also contains a listed building. Now, I won't go into the detail of that assessment. That may be something you wish to raise in the context of Matter 8. But what I would say is that it's a thorough assessment. In the case of the scheduled moated site, it concluded there were no direct impacts, and the change in setting was considered minor and less than substantial. And in relation to the Latin Priory, SAM and listed building, there's reference there to a significant distance of separation between Latin Priory and the limits of the built development. And the effects on the significance of the monument were considered low and less than substantial. And as I say, we can give you some more detail of that really at a later stage. It's also, I think, important to recognise that heritage has been considered as part of landscape and green belt considerations. At Latin Priory, a major issue, shall I pause while that... okay. Heritage was considered as part of landscape impact assessments and green belt purposes. And those considerations, those assessments were combined. And in the case of Latin Priory, really, it's all about landscape containment. And we largely agreed with the council on the limits of built development, partly on the basis of protecting the setting of the historic assets on the site. Now, more detailed work is being done on this through the strategic master plan process. I would say we support the proposed modifications. Again, I think that's probably something to be considered through the Matter 8 session. Lastly, if I could just pick up on what Mr. Koski referred to in connection with Latin Priory. He made reference to the case put forward by Tom Hill QC on behalf of my clients, that the site could support higher densities and capacity. Now, we may return to that issue at Matter 8. Indeed, we would like to do so. I think there are further considerations there that we would like to put forward. But the key point is that it's very clear from our own HIA that increased density could have no effect on the historic assets on the site. Because the increased capacity and density would be within the current allocation boundary. Now, the crucial considerations there in terms of impact on historic assets are the distances of separation, the lack of intervisibility, and the topography. So I think it's very clear that that case, which you will no doubt consider further, for increased capacity and an increase in densities to quite average levels, would have no impact on heritage assets, and we've done the HIA work to support that. Thank you.
Thank you, Ma'am. I sense I may have sort of the graveyard shift here, so I'll be brief. Probably speak for a couple of minutes. Oh, excellent! You've saved me the pleasure. I'm going to do a very brief summary on where we've got to on Greenbelt and then provide our wider observations on the site selection methodology. And then just to finish off, I will just provide you with a brief comment on my client's other site in Coopersale. But very briefly, in terms of the Greenbelt summary, we've already spoken about the fact that when deciding which sites to allocate in the submission local plan, and I'd refer you to page B1087 of document EB805P, the Council has incorrectly concluded that bands south of Epping will have a less harmful impact on the Greenbelt when considered against alternatives. As we discussed at the last hearing session, the rest of the evidence base clearly concludes that Epping South does in fact have a greater impact on the Greenbelt, and this statement is therefore incorrect. The extent to which this error has influenced the submitted local plan is unclear. We can only reasonably conclude that the impact of this error was, however, significant, given the lack of other justification for deallocating my client's site in document EB805P. As I've mentioned, we've already been through this, and I think you've noted these concerns, so I really wanted to focus on what we consider to be wider errors in the application of the site selection methodology. And these relate to the key weighting of issues and the objective assessment of preferred sites. I maintain that in the context of Epping, the evidence base that the Council has produced and the Regulation 18 plan seems well aligned. There is a clear synergy between the site selection methodology seeking to direct growth to the least harmful Greenbelt locations, to also limit the impact of development on the Epping Forest SAC, to seek to maximise growth near to the town centre and specifically the underground station, and to prioritise sites that can deliver early. However, significant changes were made to the Regulation 18 plan, but the evidence base was not, it does not appear, appropriately updated. It seems to us that the Council has simply taken the pool of sites deemed to be appropriate locations in the Regulation 18 plan and then sought to amend the quantum of growth to be delivered at each of these sites, deleting sites in the process, without first appraising the relevant strengths of each site against the site selection methodology. The impact of this error on the soundness of the plan is as follows. In light of the changes made post-Regulation 18, the preferred distribution of growth within the submitted local plan does not direct growth to the least harmful Greenbelt sites, as is required by the methodology, and specifically the sequential approach set out within it. As I've mentioned, Epping East, a reasonable alternative, has less harmful impact on the Greenbelt. The submitted plan does also not identify those sites least likely to have a harmful impact on the Epping Forest SAC. The Council's evidence base confirms that Epping South is deemed to have a greater potential for harmful impact on the SAC, given its more proximate location when compared to Epping East. The submitted local plan does not maximise the opportunities to locate growth near to the station and specifically the town centre. The closest part of Epping South is about 1,000 metres from the station. Epping East is within 200 metres at its closest point and very much within a reasonable walking distance. The submitted plan also does not prioritise the early delivery of housing. Sites which the Council have identified themselves as being available for early delivery have been removed from the plan in favour of a larger site which will deliver housing more gradually and more slowly. And as we discussed already, and no doubt we'll discuss tomorrow, the ability of this plan to deliver housing in the early parts of the plan is a key soundness issue. The above summary I just talked you through can all be reviewed by simply reading page B734 of document EB805I, which indeed is the document that we referred to at the last hearing session when I asked for justified reasons as to why Epping East was removed. Unfortunately, the reference we were given simply highlights the problem rather than provides the solution. In summary, therefore, the strategy that's put forward is not the most appropriate strategy when considered against reasonable alternatives. Why is this? Well, in our view, it's because the final decisions made were not informed by the site selection methodology, but were made because of workshop discussions that were not based on a robust planning assessment. Had the Council properly reassessed the changes it sought to make against the Regulation 18 spatial strategy, it would have concluded that the evidence base proves that providing one large allocation to the south of the settlement at the cost of other draft allocations is not consistent with the site selection methodology, is not supported by evidence, and is therefore not sound. We maintain that to overcome these issues, the Council needs to go back and properly assess the changes it wants to make to the Regulation 18 spatial strategy, and then set out clearly why these changes, if indeed they still want to make them, are consistent with the evidence base, represent the most appropriate strategy, and are therefore sound. It is our view that based on the evidence base, the most appropriate strategy is to maintain the more dispersed form of growth in Epping set out in the Regulation 18 plan, because that is aligned with the site selection methodology, and to simply stray from that would not be proper or correct. That concludes my submissions to you on Epping. Very briefly on Cooper Sale, I'd like to refer you to our hearing statement, and specifically paragraphs 1.13 to 1.16. The Cooper Sale site has site reference SR0405, and it was a site that was allocated in the Regulation 18 plan. When the submitted plan was published, the site was no longer allocated, and it only became clear when the Appendix B of the site selection report was published that the reason that it was no longer taken forward was because the council had deemed the site to be not available. That is an error, because when representations were made both to the Regulation 18 plan and to the submitted draft local plan, it was clearly expressed that the site is available. There was a site promotional document setting out how the development could indeed come forward. So to sieve the site out on the grounds that it's unavailable is a factual error, and we would encourage the council to go back and reassess that site and include it as a allocation as it did at the Regulation 18 stage. Thank you.
We'll hear from Mr. Kemsley and Ms. Bryan, and then we're going to have a break. You'll probably be pleased to know. Okay, Mr. Kemsley.
Thank you. Yeah, I represent Stanling Nasing Limited. We've been promoting this site to the immediately to the west of Lower Nasing. Site reference SR0160, which is a disused, largely vacant, derelict nursery site. Now, our concern is regarding the adoption of the results of the Stage 2 Greenbelt Review, EB705A, in particular the sensitivity testing, where this removed Greenbelt Purpose 3. This effectively skewed the assessment of Greenbelt harm, and this fed into the site selection report EB805I, the Stage 3 assessment of residential sites. Now, the Greenbelt Review Stage 2, EB705A, figures 4.5 and 4.6 illustrate the effect of the sensitivity testing. Now, these figures assess the level of harm from the release of various parcels of land. In some cases, the sensitivity testing of parcels were adjusted from very high to no harm. Examples in particular covering Lower Nasing is parcels 067.4 and 067.5, whereas other sites remained at moderate or low harm, for example, 066.5 parcel, which includes my client's site. And obviously the results of the sensitivity testing at the Greenbelt Review stage were fed into the site selection process carried out by ARUP. And this was looked at in terms of strategic options at Appendix B1.5.2. This looked at strategic options in and around Lower Nasing. Now, the southern expansion area was to proceed for further testing, due in part to the no harm arising from the release of this area of the Greenbelt, and sites within this area have been identified as the preferred site allocations within the local plan. Now, the western expansion area, which includes my client's site, confirmed that the level of harm would be low, and my client is obviously concerned that the robustness in terms of the assessment of Greenbelt harm has not been carried out. My client's sites fell out at Stage 3, and this was confirmed on the basis that officers had concluded that our site, which is a disused, largely developed, derelict glasshouse site, provided a greater contribution towards Greenbelt purposes, and therefore the preferred location for site allocations related to the southern expansion area, and in particular those greenfield sites, undeveloped sites to the south of Lower Nasing. Thank you.
Thank you. Ms. Bryan.
Thank you. I will be brief. Just so that Mr Newton isn't the sole voice in the wilderness, I'd like to confirm that my client also considers the site selection process to be robust and fit for purpose. The arguments raised around the table relating to flaws in specific elements of the site selection process don't go to the heart of the matter of soundness. It's important to note that a forensic re-examination of every stage of decision-making and a rerun of the site selection process would cause significant delay to the adoption of the plan, which in a district like this, so constrained by Greenbelt, would equate to no deliveries at all. This would not accord with the NPPF requirement to boost housing, and it would frustrate the plan-led approach. Thank you.
Thank you. I think I need a break after that, so we will be having a break now. I will give the council the opportunity to come back on some of them. I've made a note of a few things I'd particularly like them to come back on. With the best will in the world, I fear we're going to overrun. I'll have a little think about how I might deal with that during the break. I don't know if the council has any views or anybody else about that. But just out of interest, could I perhaps ask just for a little show of hands around the table who wishes to address issue 2? Issue 2. Okay. And issue 4. Okay. Well, okay. So there's a few on issue 4. Okay. Okay. Well, on that basis, we may not overrun so considerably as I thought, but I'll give some thought to that. But one thought in my mind is that obviously this afternoon, I know not everybody who's appearing this afternoon is likely to be here, but I won't need to hear from the council for such a long time this afternoon. So I don't know. I might give consideration to whether we extend slightly into the afternoon session, but I don't want it to run away. But anyway, I'll give some thought to that. But that was helpful. Thank you. It's 11:45. Should we come back at, say, 12:05? Gives 20 minutes for everybody to... Thank you. Okay, thank you, everyone. So it's 5 past, so we will make a start. Just a couple of things before we go back to the agenda. You'll notice I've taken the bold step of removing my jacket. Everyone else should feel free to do the same thing. It's very, very warm. I think it's very difficult to make the room cooler without people being able to hear, and I thought it was preferable to take off my jacket than fall asleep or faint. So everybody else should feel free to do the same if they want to. Secondly, on the timetable, unless anyone feels strongly differently, having now had a pause and a think about it, I think we'll push on the basis that the next question under issue 1 is really one for the council, and I'll explain why. That not to preclude anyone making a comment, but it's mainly a question for the council. And then in light of the relatively small number of people who want to speak on issue 2 and issue 4, I think we'll be able to get through it, even if it means a slightly later lunch. So apologies to anybody who might have to start a little later for the afternoon session, but as I say, the council won't need to speak for quite so long in the afternoon session, so we may catch up a little bit there. Does anyone have any significant concerns about that before we can always review? if we get very late. Okay, so without further ado then, pushing on, the next question, I was just wondering if I should let the council come back on some points now before we move on. Okay, there were a couple of things I particularly wanted a comment on. The first is the relative priority to open space, which has been raised by a couple of people. Do you want to take that one now, and then we'll go through them in order?
Okay, so I think our response to question 4 in the hearing statement sort of goes to the heart of the council's position on this matter. So the allocation of open space sites is only proposed in the local plan submission version, where it will not affect the adequacy of open space provision within that settlement. And in coming to that conclusion, the council has drawn on the open space strategy, which is EB 703, and the infrastructure delivery plan, which is EB 1101A and B. And in particular, in paragraph 24 of our hearing statement, we draw a reference to the site allocations proposed in each settlement in combination being looked at in terms of the impact on open space provision. So this wasn't done on an individual site basis. We looked at the proposed or the recommended sites for allocation and looked at their totality in terms of the impact that that would have on open space provision within that settlement, and therefore only put forward sites for allocation where the evidence supported that there would still be adequate provision of open space.
Thank you. I don't want to go further on that now, but you'll notice if you've seen it, you might not have seen it yet, the agenda for the DM policies session asks a specific question about that, because several representatives have raised the issue that it didn't look perhaps at the implications for when development was made. So for those sessions, if you could talk about that, that would be helpful. Thank you. Can I just ask a sort of blunt question, I suppose, is why you preferred open spaces within settlements such as Jessel Green to an open space potentially on the edge of settlements, knowing that the scale of objection that there was in Jessel Green?
This was a very careful consideration by the council, but the priority was to ensure that we had as little green belt take as possible. So the priority was to minimise the amount of green belt that was proposed for allocation. So we looked within settlements before looking outside settlements.
I was wondering if you could maybe just comment on the issues raised by Mr. Hawes in relation to the loss of the business on the Loughton allocation.
Yes, as far as we're aware, that's a landlord and tenant matter. TfL, who are promoting the site, made representations to say that it was fully available.
Did you want to say anything about his concern that the local plan doesn't give adequate consideration to the protection of small businesses?
I think we do within the employment policies. Maybe we'll cover that through that conversation.
Thank you. And perhaps if you could just come back on the point, I think it's been raised by several people around the table in relation to the council and the member workshops, the role of the member workshops. Mr. Simmons raised it. His concern, I think, was that those workshops were making judgments that weren't based on planning or technical grounds, and that they didn't take full account of the results of the site selection report, which would potentially have found those sites to be suitable?
Yes, certainly. I think, as I mentioned in the opening remarks, the member workshop at stage 6.4 did not take place. So the final member workshop for the final selection of sites didn't take place, and that was because the process was truncated in order to get to full council in December 2017. Instead, we had a member briefing session at the end of November, 28th of November, in which officers advised, based on the technical evidence, the sites which were being proposed and which would be in the report considered by full council. So members did not have involvement at that final stage. It was based on officer workshop and the technical assessment work that we had undertaken, which did include consideration about early delivery. That was one of the factors that was a consideration at that stage in the process. I think it's important to recognise that throughout we've tried to take a proportionate approach in relation to site selection. We have had a large number of sites, I think many more sites than most authorities have to assess and to deal with, and we've sought to take a proportionate approach. Just picking up a couple of other issues, the meetings that we held at the Regulation 18 stage with promoters of sites weren't 20 minutes, they were 45-minute slots, and we saw approximately 60 promoters over that 2-day period. So it was a considerable resource invested by the council in that process to help people understand the site selection process through the Tranche 1 sites, and for them to understand why it was that their site was not being proposed for allocation in the draft local plan. Somebody raised issue about parish boundaries. Parish boundaries was never a consideration. We all know that people don't respect administrative lines when they walk or cycle or use services, etc. It was not even on our radar. Point about heritage assessment, Mike Newton very helpfully commented about that, but the methodology and the assessment that we undertook is set out in EB 205E at 1.8a on pages B199 200, and that followed very much the Historic England guidance in terms of the assessment we did on all sites at stage 2 or stage 6.2.
In relation to the point, I think it was Mr. Ireland that made the point about the parish boundaries. He also made the point, I did ask at the beginning, but I'm not sure I'm clear on it, about where the buffer zones are mapped.
I'm not sure that they are mapped, other than in the Green Belt review in terms of identifying the parcels that went through to the stage 2 Green Belt review. Obviously, one of the factors that was taken into account in drawing up the buffers were existing defensible boundaries, and in relation to the Loughton Debden area, obviously the M11 goes up to the east of Loughton Debden, and that was considered to be a defensible boundary, and that's why the buffer zone didn't go beyond the motorway. There is a map in the Greenbelt Stage 2 report which sets out the buffer zones. We will find the reference for you. I'm told it's figure 2.2.
And just a couple of other points. If you could comment on Mr. Shah's case about how his site has been treated inconsistently, in his view, with 4 other gardens, houses with gardens.
Would it be something that we can come back to you separately?
Yep.
On?
Thank you. Finally, did you just want to, I think it is covered in your statement somewhere, but I think it was Miss McSweeney that made a comment that sites weren't visited, and that has compounded some errors that were made in desktop assessments.
I'm not sure the council has more to add than what is in the hearing statement.
Thank you.
Which is paragraphs 18 to 20.
Okay. Is there anything more the council wanted to come back on before we move on? No, thank you.
No, thank you.
Thank you. Okay, so we're going to move on now to the bullet point on my agenda that says utilising the capacity of suitable sites. I know that Mr. Simmons does want to make a comment on this. I don't want to preclude anybody, but essentially, I think most of the positions I've heard around the table says yes, there are more sites that can be used. So I don't need anybody to say yes, there are more sites that can be used. So unless you want to say something more sort of more fundamental than that, I'd be interested to hear from anybody who disagrees that there are more sites that can be used. But really, I think it's a question for the council. So if I hear from the council, Mr. Simmons, I know you want to make a comment, but really anybody else, and if it's just yes, on the basis of all we've said, of course there are more sites, then I know that that's your position. I don't need to hear it. So you've read my question. I've come from the council. Thank you.
So at the Matter 4 hearing, the council explained the land preference hierarchy and its role in site selection. We don't propose to repeat the detail of that response, but note that it is relevant to this question. I don't know, Madam, whether it's helpful for me to summarise what was said at Matter 4, or whether I can just move.
I think it'd be helpful. I think if you could be as clear as you can, because I think it's a fairly fundamental point that people are raising.
So, in summary, the council explained at the Matter 4 hearing that the land preference hierarchy seeks to distill the key principles from the 2012 framework and the key issues facing the district that may affect the location of development at a settlement level. This was to enable the council to identify the most appropriate sites in each settlement, subject to the distribution of growth identified through the local plan strategy and the full range of material planning considerations. The land preference hierarchy does this by categorising sites against three considerations. The first one is level of flood risk. The second one is the type of land, so is that brownfield and greenfield within the urban area or green belt, and the location of the site in relation to existing settlements. And the third consideration is grade of agricultural land. The land preference hierarchy was used to filter those sites that were judged to be suitable through the first couple of steps of stage 3, and to identify which of those should proceed for deliverability testing. This was given the large number of sites promoted to the council. And as Ms. Blom-Cooper just mentioned, I think over 800 residential sites were promoted to the council for assessment. As the site selection report, which is EB 805, explains, all sites judged to be suitable and located within categories 1 to 4 of the land preference hierarchy, which comprises sites in flood zone 1, which are either urban brownfield, urban greenfield or open space sites, previously developed greenbelt and least value greenbelt located adjacent to the settlement, were taken forward for deliverability assessment. And that's set out in para 2.81 at page 27. In addition, for some settlements, sites in categories 5 and 6 of the land preference hierarchy were taken forward for deliverability testing. These are sites in flood zone 1 on greater or most valued greenbelt adjacent to settlements. Paragraph 2.81, which is pages 27 to 28, provides further detail on this, including the reasons why for specific sites the reasons why for specific settlements additional sites were taken forward. The council considers that this approach is justified, it reflects its local plan strategy and supports focusing growth in higher order settlements whilst providing the opportunity to meet local needs in smaller settlements. Regarding why more sites could not be allocated, the Council acknowledges that from a site-based perspective, it may be theoretically possible. However, in reaching a judgment about the appropriate level of growth to allocate in the local plan submission version, the Council has had to balance a range of other factors, most notably the impact of growth on the Epping Forest Special Area of Conservation and the impact of growth on the district's infrastructure, including the transport network. The Council considers that the local plan submission version represents a finely balanced package which achieves net gains across the 3 dimensions of sustainable development as required by paragraph 152 of the NPPF. Furthermore, there is significant public interest in the Council adopting an up-to-date local plan as soon as possible. The need to reconsider the site allocations within the local plan submission version would result in considerable delay, requiring the Council to undertake significant amounts of additional technical assessment work. This delay would exacerbate the housing challenges the Council is currently facing, including addressing the housing shortfall accrued since the beginning of the plan period, and the need to accelerate delivery rates, as demonstrated through the recent housing delivery test results.
Thank you. So just turning back to my question. So at the end of, is it at the end of stage 3, you had more sites than you needed to make the numbers, the target that you'd set work. Can you then, sorry if I just want to be very clear on this. Can you then just explain again then the types of sites that got filtered out? I guess I'm keen to know how it ended up at almost being sort of, has it ended up as being precisely the number that you need, or?
Apologies, I thought the number was neatly in a paragraph, but I can't seem to find it right now. Okay. Table 2.7, which is on page 33 of EB 805, so that's the main report, provides a summary of site ranking by settlement, and it shows for each settlement which categories were taken forward. If I just show you what it looks like. And at the end of that table, it provides a total number. And so the number of dwellings that all the sites that were judged to be suitable could provide was over 29,000 homes. And in terms of the number that went forward for further testing, I can come back to you separately after the break if that helps, on the number that was taken forward precisely, but it was well in excess of the residual housing requirement.
No, I realise that, but what I'm trying to be really clear on is how so that I know that because that's table 2.7 I quoted in my question here. So there were a large amount. There was a 29,000 whatever that had made it through stages 1, 2, and 3. And then I think you're saying that you then filtered it on the basis of the land preference hierarchy. And I'm just trying to be really clear in my mind as to how that filtered it down. What type of sites were sort of screened out through that process? And did you stop to achieve a sort of fixed number of the requirement, or was it a sort of consistent process, and if you made it through that sift, you were in, regardless of whether it exceeded the plan requirement?
No, so the SIF number wasn't a specific number that we were looking to achieve. It was to provide a range of sites in settlements across the district. And so it wasn't to achieve a predetermined number. It was to make sure that a sufficient number of sites were subject to deliverability testing, recognising that a number of sites may not be deliverable at that stage. So it wasn't the number didn't match the precise housing requirement that the council
and is what you were saying before that I misunderstood, was that more made it through the filter and went into stage 4 than you needed, and then it was cut down again there, so that the land preference hierarchy wasn't the last sieve. You put it through the land preference hierarchy, the results of that went into stage 4, and then that cut it down further.
Correct.
Okay, thank you. Okay, Mr. Simmons.
Madam, you've posed the question, why could more sites not be allocated? I'm not going to answer the question at this point, Madam, but the issues that you will need to consider, can the plan meet objectively assessed housing needs? And of course, Madam, you've heard lots about that within Matter 2. Secondly, can the plan ensure there is a realistic prospect of a 5-year supply of housing land being achieved? And Madam, you will hear lots about that issue tomorrow. And thirdly, is there an appropriate distribution of growth between the respective settlements based on the council's settlement hierarchy? And Madam, that is a matter that you heard about in Matter 3. Madam, a related point, and it was a question that you raised in your original agenda for Matter 5, is why were some sites removed from Regulation 18 and not replaced? You've heard evidence from many this morning, Madam, that promoters of the site are of the view that there were not sound planning or technical reasons in many cases. With regard to my client site, Madam, the apparent explanation is set out in Appendix B, notably within Appendix B1.6.6. We believe, Madam, that those points raised simply don't stand up to scrutiny. And in the context of the question that you have raised, we do consider that our site, Madam, has merit, as indeed has been accepted by the council and their consultants. What is particularly relevant, Madam, is to the matter that you hear tomorrow about deliverability, that our site is deliverable within a 5-year period. The merits of the site, Madam, I'm not going to repeat all of the points, but outside of this examination, can I refer you to para 3.15 of my Matter 5 hearing statement? But, Madam, you should be fully aware that our site has particular benefit and merit on the basis of its position adjacent to Thaden Boys underground station, and notably it has direct access onto the station. And Madam, we say that it is the most sustainable of the sites considered by the council for release from the Green Belt. But coming back to the relevance of your question, Madam, we say the deletion of our site is significant in terms of your consideration to the plan's soundness. The reason it is significant is that the deletion of our site from the Regulation 19 version of the plan takes away 130 dwellings from Thaden Boys. Thaden Boys is a large village. It is one of the most sustainable settlements in the district by virtue of its proximity to the underground station. As you've heard, Madam, in previous sessions, we now know that there is capacity on the central line. So accordingly, sites that are close to or next to underground stations, of these central line underground stations, do have importance in terms of their potential to accommodate housing. Madam, the Council have said in their Appendix B response that there are more preferable sites to provide for the desired growth in Thaden Boys. Madam, we say, where are they? The deletion of housing allocations in Thaden Boys has simply not been replaced. And this, Madam, is an important factor in terms of the strategic policies of the plan and the objective to comply with the settlement hierarchy. So this is not just about a site-specific objection, Madam. This has a bearing on the strategic objectives of the plan. And Madam, we feel that you should give particular consideration to the ability of Thaden Boys in its status as a large village to accommodate significantly more growth.
Thank you. I will hear from Mr. Bell and Mr. Ireland, but I think I want to move on. But I want to ask just one question of the Council while it's still in my mind. Perhaps you could use as an example Mr. Simmons' site. If we go back to the question I just asked about would the decision that was made about his site to remove it at the Regulation 19 stage, and indeed the same might apply to any of the others that were in at the Regulation 18 and out at the Regulation 19, does the sort of sifting process, and we've just heard about sort of cutting down sites that made it through stage 1, stage 2, stage 3, and then the land preference hierarchy, and was that any reason for removing his site?
No, so the appendix that Mr. Simmons refers to is EB 805P, which is on the diagram that was circulated this morning, is the appendix which is under the sites for allocation stage. So the site proceeded all the way through up to that point. If I'm just, whilst I'm speaking, the paragraph that I was looking for earlier in terms of the number of sites that were taken forward for deliverability testing is paragraph 2.97. I think that confirms something like sites with the capacity to deliver 23,000 homes were taken forward.
Okay, so there are sites. So there are sites like Mr. Simmons' site that made it all the way through the site selection process and were then deleted at the end for other reasons which don't necessarily relate to the suitability of the site. Okay. Thank you. Thank you. Okay, so we'll take the ones around the table, then I'm going to move on to the car parks after these. So, Mr. Bell.
Thank you, Ma'am. My point can be very brief, just in light of your clarification with the council. I just wanted to highlight to you, my client's in a very similar situation to Mr. Simmons. The site we promoted on the edge of Chigwell, it's reference 16_site_02NC. That site similarly reached the penultimate stage of the site selection process. The council accepted that it was available within the first 5 years and that there are no identified constraints to its delivery. It was just a case that the council had decided that cumulatively there was a desired level of growth already achieved at Chigwell, which of course we contest as set out earlier.
Thank you. Mr. Ireland.
Thank you. Hopefully quite a quick point from me. The council have helpfully just clarified that in the way that they've looked at Loughton and Debden, they've treated the M11 as effectively the eastern boundary to the settlement. But that's the first time, in essence, that that's been really set out in any transparent way. So I think there's a particular issue of transparency around that. But I do think there is then a question about whether that is justified. And there is a relationship between what's being considered here, I think, and the Matter 4 discussion that we had a few weeks ago. And so the Council's statement for the Matter 4 sets out that the site selection report in 2018 in its appendices, I'm quoting from the Council's own statement, show that Loughton, while being the largest town in the district, is one of the most constrained. There's a lack of suitable brownfield sites within the urban area, and locations outside of the settlement boundary are constrained by high-performing greenbelt, flood risk and ecological designations. But that conclusion is only drawn within the frame within which that settlement boundary has been defined. And I would have thought there was a reasonable and logical approach to, well, you know, if you look at it in those terms and find that there are particular constraints in essence to the growth of the settlement in certain directions, that given it is the largest town in the district and a sustainable location for growth, that you do look elsewhere, including effectively on land on the other side of the motorway, which can also be defined by defensible boundaries. The parcel on that side was a low-performing greenbelt parcel, but is bounded by a set of roads. So do you think that approach in terms of how that issue has been looked at just doesn't quite stand up?
Thank you. And Mr. Churchill.
Again, relatively brief. We heard the council make the point that a significant amount of additional work would be required in order to assess those sites. That's a proposition I think we need to reject. If a proper detailed assessment has been done, it should and could be a relatively easy process of identifying the next cab off the rank, if I can put it that way, that's needed in order to meet under supply or under delivery. And obviously, my client site, I would put forward, particularly where it's removed erroneously at EB 805 stage on an on-balance decision.
Thank you. Did the council want to come back on those few points before we move on to the car parks?
No, thank you.
Thank you.
Madam, sorry, could I
Very
just...
briefly, Mr.
Sorry,
Simmons.
it's a question for the council, really just to seek clarification. You put the question to them about the reasons for the deletion of some of the sites. And I think the council, in their response, accepted that some of the sites were deleted for non-planning reasons. And really, Madam, we would like to know what those reasons were.
Well, they didn't say non-planning reasons. They said that they were removed for other reasons, which I think they say are reported in EB 805P, that were not for reasons related to the suitability or deliverability of the site, which is slightly different to whether it was planning-related reasons.
Okay, that was EB 805.
P. Unless the council wants to say anything more, we'll leave it.
No,
there.
you're correct.
Thank you. Okay, so moving on now to the justification for the allocation of station car parks. Again, we'll follow the same format. If I hear from the council first, and then one go each for anybody that wants to speak on these. So there are some station car parks listed there and other car parks. So the first point is evidence that sufficient parking for commuters and residents can be provided on Loughton R1, Buckhurst Hill R2 and Thaden Boyce R2. Now, the reason for asking that question is that the council's pointed to high-level feasibility studies in EB 803, I think, to demonstrate that existing parking for commuters can be re-provided, along with additional parking to serve the new residential development for sites Epping R3, R6, R7 and Loughton R2. So if that's correct, is there similar evidence to demonstrate it's possible for the other car parking sites? Next question is, what form of development is envisaged on Loughton R1 and R2 to achieve the requisite density, and is that compatible with the surrounding area? Reference has been made in that respect to non-designated heritage assets. And then the last two questions there are fairly self-explanatory. Does or should the relevant policy wording for each site require existing commuter parking to be re-provided along with sufficient residential parking, and is it necessary to specify the number of spaces? And then there's a proposed modification concerning how to deal with short-term disruption for commuter parking. And for anybody's benefit who hasn't seen that, it's for each relevant site. The council proposes a modification to Appendix 6 to require this matter to be addressed in construction management statements. So if I could perhaps hear from the council on all of those points, then we'll take points around the table. Thank you.
Thank you, Madam. As set out in the Council's hearing statement, and I refer you to paragraph 27, the settlement capacity study to which you've referred was used to establish the feasibility of re-providing existing number of commuter parking spaces already on site and making sure that there were appropriate levels of parking to meet the needs of future residents of any development. The principles established through the settlement capacity study, and that's EB 803, have been applied to the three sites that you've set out in your agenda through the capacity assessment undertaken as part of the site selection process. And appendices B 1.5.3 and 1.6.4 set out the methodology followed and the results of the capacity assessment for those three sites. Consistent with the principles established in the settlement capacity study, the local plan submission version recognises that these sites should have low levels of resident car parking provision in accordance with paragraphs 30 and 39 of the MPPF, given their proximity to public transport. And that's reflected in the site-specific requirements that we've set out in Appendix 6 for each of the sites. Council notes that Transport for London has submitted a hearing statement which confirms the approach to car parking proposed by the Council, and the proposed site capacities are supported by Transport for London. I refer you to their paragraph 1.17 on page 7. Council considers the approach it has adopted as proportionate and provides sufficient comfort at the plan-making stage that the proposed number of residential dwellings can be accommodated alongside replacement commuter car parking and the appropriate level of future residents' car parking. Turning to the type of development envisaged on those sites, based on our technical work, the Council consider the form of development on sites LOUR1 and LOUR2 would most likely be flatted development, although obviously this would be determined by the site promoter at the planning application stage. That view was informed by the high-level feasibility designs which were undertaken at the settlement capacity study as part of the settlement capacity study. And if you look at Appendix 8 to the settlement capacity study, that specifically looked at proposals for LOUR2. Which showed a number of relatively low-rise apartment or mansion blocks could be accommodated on the site. And the principles of that were considered applicable also to LOUR1. The capacity assessment of both sites was undertaken drawing on the principles established through the settlement capacity study. The settlement capacity study itself took account of the local context in looking at site visualisations and capacity, and it went itself, those site visualisations and the various sites that were considered at that stage in the settlement capacity study went through a check and challenge process undertaken by the local planning officer working group here at the council. Through that, the consultants' initial visualisations were challenged in terms of the context and their relationship with the surrounding context. In addition, as part of the site selection assessment, regard has been had to the character of the surrounding area, and this has been weighed up in coming to a view on potential site capacity. So the council considers the proposals are compatible with the surrounding area. In relation to particularly to LOUR2, it should be noted that the proposed capacity put forward in the local plan submission version allocation is lower than that was identified through the settlement capacity study and the visualisation process, design process, feasibility that it went through. And we therefore do consider the capacity for that site is a conservative estimate. Turning to the relevant policy wording for each site, the Council will confirm in relation to its response to Matter 15, Issue 1, Question 1, that Appendix 6 to the local plan submission version is intended to constitute policy, and we are going to propose amendments to Part A of each of the places policies in order to clarify Notwithstanding that, Appendix 6 to the local plan submission version does include the requirement for the reprovision of the existing number of car parking spaces for all the car park site allocations. And the council considers that sufficient and that there's no need to specify the precise number of spaces.
Sorry, my question there mainly related, I think, to the number of residential spaces. Is it necessary to be specific about the number of residential spaces?
The council is committed to doing a review of the car parking standards, and obviously what we've included in Appendix 6 is a requirement to have reduced residential car parking requirements, particularly at the car parking locations close to stations. So we will be looking for car clubs, travel plans, and reduced amount of car parking, just to take account of people, blue badge holders, etc. And I mean, obviously that is a requirement in terms of sustainable transport and need to mitigate the impacts on Epping Forest Special Area of Conservation as well. And that's set out in Policy T1 in the local plan submission version. In relation to the main modification, as you've indicated, we are proposing a modification to Appendix 6 in the terms that you've read out.
Okay, anybody else? Thank you. Mr. Taylor.
Madam, thank you. I'm not sure if this is the right place to make this point, but you will have seen from my client's hearing statement, page 3, that it presents a summary of findings of an examination of the viability of 5 of the car parking sites. There's an investigation into whether, in fact, those sites are likely to be delivered at all. And we've just heard confirmation that I think I understood it right, that the council's approach is going to be that it's going to insist on the number of existing spaces being re-provided, but no additional spaces for future residents. That's what I'd understood was being said. That is appraised on page 3 in table 1 of my client's hearing statement as option 2, and of the 5 sites identified, 4 of them don't deliver any surplus at all, and the final site delivers such a small surplus no affordable housing would be delivered on it. So in terms of the feasibility and the justification for allocating these schemes, my client, as you will see in the conclusion on page 4, has presented evidence that suggests they're unlikely to be deliverable on the timescale identified in the trajectory, or indeed at all.
Can you just clarify? I'll go back and have a look at your client's statement. But is that a viability study drawn from the council's viability work, or is that something that's been done separately by your client?
I think it's a combination of the two. To be fair, you'll see that they've drawn on the experience of a QS firm, Betteridge and Wilson, and also the valuation and viability consultant Stratton Parker. They've examined 5 sites, and although it doesn't look at the capacity of the sites, what it does is take the information that we've got and utilise an order of cost estimate that's set out in Appendix 6 of that document, and it gets you to Table 1. The implications, of course, of the work that's been done is that the site's capacities would have to rise in order to generate more income. That means the buildings will have to be taller. That in turn has implications in terms of acceptability of design, and indeed in terms of potentially on some of these sites in terms of heritage impacts. And we know from the discussion we had earlier today about the status of the heritage impact appraisals, or rather lack thereof. All of this ties back in. They're all points that in my submission you need to have regard to in drawing a judgment as to whether the allocation of these sites is actually justified on the evidence.
Mr. Simmons.
Madam, we have concerns about the housing allocation at the Thaden Boys car park. Madam, it's the only dedicated car park that directly serves the underground station. And importantly, there is no other public car park in Thaden Boys. Based on our observation and experience, the car park is very well used and there are very rarely any spaces available during the working days. And indeed, Madam, owing to parking restrictions in Thaden Boys, it is known that there is an ongoing problem of commuters parking along Abridge Road and also elsewhere in the village. It is assumed that proposals for the redevelopment of the car park will require the retention of car parking, but we can't see from either the plan or other submissions the precise details. Of course, if there is the loss of any car parking spaces for commuters, that would be highly undesirable. But, Madam, even the loss of spaces for a temporary period during the construction stage will add greatly to pressure to park elsewhere in Thaden Boys during that time. But, Madam, in any event, in terms of deliverability and viability, and really endorsing the point that Mr. Taylor has just made, we feel that the prospects of a viable development coming forward on this site are questionable. The site is allocated for 12 units. Is this viable in light of the requirement to retain car parking, but also to provide for affordable housing and also to deal with any other constraints on the site? So, Madam, we seriously question the suitability and the prospects of bringing forward development on this site. Thank you.
Mr. Hawes.
Thank you, ma'am. The council again reiterated the desire to explore car clubs at the station sites where they're not providing any additional residential housing, parking, sorry. And again, we'd refer them to our suggested changes in our Regulation 19 submission, where we suggest that we get retained within the proposed development, where not only could they help us retain an established provider, service provider, also preserve jobs for existing people within the area, but also support the NPPF guidelines on promoting sustainable transport, reducing greenhouse gas emissions with the use of low and ultra-low emission vehicles, which we could supply as part of a car club or a car hire scheme. Thank you.
If I could just ask the council to come back on those points, particularly in relation to viability and Mr. Hawes' point there, and then we'll move on to issue 2. Thank you.
Yes, the settlement capacity study work included within the sites that they looked and took forward to the appraisal process included viability assessment, and that included taking account of the affordable housing requirements and so on. The conclusion of that was that these were viable developments, and although we haven't done it for every single site, we have transposed that information across to the other sites.
Sorry, so just to be clear there, because obviously we're moving on to viability. You're saying there's been a sort of specific look at the car park sites?
As part of the settlement capacity study, the council was seeking to maximise the sites within, brownfield sites particularly, within settlements that could be brought forward for development. As part of that work, they identified a number of sites, including not just the car parking sites near the stations, but also some town centre car parks, to see if they could be brought forward for development, both for residential development whilst retaining the car parking. As part of that work, they then took forward a number of those sites, I think it was about 12, which they looked at in more in depth and did visualisations to test whether or not it was possible to bring forward viable development on the site. So they did visualisations and a high-level feasibility study, which included some, block diagrams and drawings, which are in that Appendix 8. But they also undertook a viability assessment of those specific schemes to check that those were deliverable schemes. And it was on that basis that schemes like that were then taken forward through the site selection process.
And where is that reported?
It's in the settlement capacity study report, and the visualisations specifically are in Appendix 8.
Appendix 8, is the viability information in the same?
I'm not sure if it's in the same, that appendix, it's probably in one of the other appendices. I can find out which one.
Okay, yes, please. Thank you. Did you want to come back on Mr. Hawes's point?
I don't think I've got anything more to add to what we already said.
Okay. Thank you. Okay, so we'll move on now to issue 2, which is, have the plans allocations for gypsies and travellers and travelling show people been chosen on the basis of a robust assessment process? Now, again, I've got some red text on mine, which I'll just read out before I ask the council, so you know where I'm headed. So the first bullet there, the justification for allocations within strategic master plan sites within the Garden Town, North Weald Bassett and Waltham Abbey. So my question there is, how was it decided that the strategic master plan sites within these areas should accommodate traveller sites? Were they put forward for assessment? Are they suitable in terms of their physical relationship to the settled community? Then the second point, which you have covered to some extent in your statement, it's really a clarification I'm seeking here. So were existing sites for redevelopment and expansion assessed against the site selection criteria in the traveller site selection methodology in the same way as potential new sites? And there, did this include consideration of greenbelt harm, as well as the potential for over-concentration of traveller sites? And I just wondered if there's a particular concern about over-concentration in Roydon, because that's come up a couple of times. Okay, if we deal with those two, and then we'll look at the sequential approach. I'll ask you that question in a moment.
Thank you. The local plan submission version proposes to allocate land for the provision for traveller sites in the following locations. So it's 5 pitches in the North Weald Bassett Master Plan area on site allocation NWB T1, 5 pitches in the Waltham Abbey North Master Plan on site allocation WAL T1, and then 15 pitches across the Garden Town communities, the 3 sites, 5 in Latin Priory, 5 in Water Lane and 5 at east of Harlow. The inclusion of the traveller pitch requirements within the wider residential allocations in North Weald Bassett and Waltham Abbey were proposed following their assessment through the site selection process. So site allocation NWBT1 was assessed through the site selection process under site reference GRTN_06, and WALT1 was assessed under GRT-N_07. Both those site allocations were originally sourced from a pool of sites which had been identified in a draft traveller development plan dating back to 2008-2009 and form part of the Tranche 2 sites that were considered. Okay, so in accordance with the traveller site selection methodology, the council contacted the landowners of each site to establish their interest in either selling or leasing land for the purpose of providing additional traveller site accommodation in the district. And that's set out in stage 2 of the traveller site selection methodology. As documented in paragraphs 3.43 and 3.44 on pages 60 to 61 of EB 805, sites only continue to progress through the site selection process if a positive response was received from the landowner, noting that this could be in conjunction with residential development taking place as well. A positive response was received from the landowners of sites GRT N06 and 07, and therefore those sites were subject to the remaining stages of the traveller site selection methodology, including the major policy constraints assessment, which for the travellers' sites took place at stage 3 or 8.3. the suitability assessment at stage 4 or 8.4, and then the deliverability assessment at stage 6 or 8.6.
Thank you. So just again to make sure my understanding's clear, so they were identified by the the potential was identified by the council through the draft Traveller local plan, but then you did contact the landowners, and this is in relation to North Weald, Bassett and Waltham Abbey at the moment. Yes, we can come on to the others.
Yes.
And you received a positive response from the landowners, provided it was in connection with residential development. Is there evidence of that positive response?
Yes. I mean, I'm sure we can provide copies of that if you would find that helpful.
Yes, please. Okay, carry on. Thank you.
And the overall write-up and the justification of the allocation of those sites is set out in Appendix E 1.8.3. Okay. Because those the number of the requirement, Traveller requirement, was over and above what we found through that process. Traveller requirement of the Garden Town communities was proposed, since there was not sufficient provision elsewhere in the district. That approach is consistent with the site selection methodology, with the Traveller site selection methodology, I should say, and the sequential approach which is identified at paragraph 51, page D17. The Council's local plan strategy has sought to avoid over-intensification of traveller populations in a single part of the district, and then that's picking up your point about Roydon. And since the pool of potential sites assessed could not demonstrate sufficient provision to meet identified need for additional pitches, decision was taken to accommodate traveller pitches within the Garden Town community sites.
Sorry, say that last bit again.
Because essentially we didn't have enough sites put forward across the rest of the district, and in order to avoid over-concentration in particular parts of the district, we took the decision to include traveller requirement within the Garden Town communities sites as the best option for delivering our requirement.
And is there a similar positive response from the landowners in the garden towns that would, I guess I'm looking for some indication, I suppose, that these are actually going to happen if nobody who's responsible for delivering the sites wants them to?
Well, it's always been a requirement. It was in the draft local plan. I'm sure they will make their own representations to you, but we consider that we can deliver them, and because it's a policy requirement, it will be undertaken through the master planning process that we are working with those site promoters on at the moment.
Before I ask you just about the sequential approach, you mentioned Roydon, but is there currently a concentration in Roydon? Well, I'm just wondering why people are raising concerns about Roydon.
Yes, there are a large number of existing traveller pitches in that area. One of the consequences was the council have tried to go for a disperse, but travellers generally want to live in that part of the district. They want to live within their existing communities. So there's a tension, and we've sought to achieve a balance.
Okay. Just moving on to that final question, so I've heard everything from the council. The sequential approach to site selection in SP2D, this might just be my own misunderstanding. I'm just going to turn up SP2D. Okay, page 32 of the plan. My question 2B on my MOQs asked whether it was justified to prioritise the provision of new gypsy and traveller sites in the countryside and greenbelt over making provision as part of the development of other allocated sites. I think that's probably, it's almost the opposite of what we're hearing, that you're not actually doing, it doesn't seem that you are actually doing that, because you are putting them in other allocated sites. But and I think that's perhaps what your statement is saying, is that you don't do that. But SP2D, the sequential approach therein, does seem to do that, as far as I can see in my reading of it. Perhaps you could just explain how that's been used, even if the outcome hasn't been the same. So let me just see if I can explain why I'm confused. Okay.
On this point, I think one of the problems is that there is an error in the translation of the sequential approach into policy SP2 little d, so that point 5 of SP2D shouldn't say and other allocated sites in the local plan. It should just say the provision of land as part of the development of the garden town communities around Harlow, because we've already taken account of the other sites further up in the sequential approach. So in a sense, the use of the provision of land as part of development of the garden town communities was further down in the sequential approach, and was only went to when we'd exhausted all the other options and opportunities.
So sorry. So I'm looking at is point 4 and point 5.
Yes.
Essentially, my question is: I think some people have said they should be the other way around.
We're saying no, they're the correct
That's
way
the right
around,
way around.
But we should be deleting another allocated sites in this local plan from little 5. Because they form part of little 4.
And so then the question would be: why is it justified to? Why would you prioritise sites in the green belt?
Well, it goes back to the heart of the conversation that we were just having about trying to ensure that we were providing across the district and not just over-concentrating in certain parts of the district.
Okay. Thank you. And then in any case, my last question was a bit like in the housing, in relation to housing, is that sequential approach required now that the allocation is complete?
No.
No.
But you have missed out, and I don't know whether you wanted to cover this, that where existing sites for redevelopment expansion assessed against the site selection criteria.
Oh, yes.
In the same way
Okay,
as potential
yes,
new
please.
sites.
Yep, okay.
So generally speaking, a consistent process was applied to all existing and potential traveller sites. There's 2 exceptions. The first one is as part of stage 1 or 8.1. This involved the identification of a pool of potential traveller sites. These were collated from a range of different sources, and depending on the site source, some additional assessment was undertaken at this stage. This is explained in the Council's Matter 5 hearing statement, paragraph 33. Section 3.4 of the site selection report, which is EB 805 on pages 57 to 60, and the traveller site selection methodology, which is paras 15 to 21, and para 71, which are pages D5 to D14 and D21. The only other exception was for traveller sites assessed in 2016. As Ms Blom-Cooper's talked about, there was this early availability SIFT, which is stage 2 of the traveller site selection methodology. This stage was undertaken exclusively for new sites and not for those involving regularisation, intensification or expansion. And this decision was made on the basis that the council already knew such sites were available, having those sites already been sourced through planning application history and records of unauthorised occupation of land, and that's explained in section 3.5 of the site selection report on page 61. From there on, all sites were assessed on the same basis for the remaining stages, and that includes the same criteria being utilised.
Thank you. Okay, can we hear from, is it Miss Bryan wanted to speak on this one? Thank you.
Yes, thank you. As set out in full in my hearing statement, I feel that no justification has been provided as to why it's appropriate to locate the traveller sites within the residential-led master plan areas. This is on the basis the council's own evidence indicates a strong preference for a degree of separation between the traveller and the settled communities. This is in the LPSV itself at paragraph 3.25, and it's referenced in the site selection methodology. I think that's paragraph 19b. This screened out sites adjacent to residential areas at stage 1B, no, 1A, sorry, 1A, that were already close to residential property. So it was sort of the reverse situation of the buffer zones for the residential sites. They actively did not consider any sites directly adjacent to residential development. But despite this, and I'm not saying I disagree with that approach, however, the result of this, by putting the traveller sites within the master plan areas, is that there are sites proposed for allocation within the residential-led master plan areas, meaning the traveller sites and the residential uses will end up in immediate proximity with each other, which is what my understanding of the site selection methodology tried to avoid. So my client owns land both within and without the North Weald Bassett master plan area. Land within his ownership is available for this use, but in light of the evidence about the separation between the traveller and settled communities, we consider it would be more appropriate to locate it on land outside of the master plan area. And can I make sorry, another point on the sequential approach, or are we coming back to that? I'm a bit confused about what deleting it would actually mean, because would this result in complete reliance on the allocations in the master plan areas and garden towns and policy H4 as the only means for delivering them? Because that to me would put quite a heavy reliance on them through the master plan areas, and there's a point that I'm going to raise tomorrow about the deliverability of these sites within the timescales envisaged, because they're tied up with the delivery of the housing on those same sites.
Just taking your last point, Ms. Bryan, I've neglected to read out something that I have written in red on my own sheet here, which was in deleting SP2D, there would be a need to retain Part D4, which would allow additional sites to be permitted under policy H4. Would that Part D4, which says, well, the start says D, talks about them being allocated, basically. And then Part D4 would also say permitting additional traveller sites in accordance with policy H4. Oh, D6. Sorry, D6, further down. Sorry, that's why you're confused. I'm reading the wrong thing. D6.
Yes, I think that bit needs to be retained.
And would that... would you be more confident if that bit were retained?
Yes, but it's still... that would relieve that policy as the only mechanism for mopping up any lack of delivery from the strategic master plan sites, which we're talking about in the trajectory session tomorrow.
Okay. Is it Mr. Spencer? Sorry. Boards them well. Thank you. We'll hear from Mr. Spencer and then we'll come back to the council.
Thank you, ma'am. I should start by saying that overall my client supports the local plan. However, they do continue to object to the allocation of a traveller site at East of Harlow. I've reviewed the council's site selection report, and there hasn't been any assessment undertaken of the East of Harlow site in relation to potential traveller provision. The 2018 site selection report refers at paragraph 3.106 to it being judged that traveller allocations continue to be required in the garden town communities around Harlow in order to meet the increased requirement figure identified in the Gypsy and Traveller Accommodation Assessment. But there's no information to explain in the evidence how or why that judgment was reached, and no site assessment for East of Harlow in that document or in the previous 2016-17 site selection report. And interestingly, I see that Boyer's hearing statement identifies a similar lack of assessment of their client sites at Latham Priory. So, in summary, there's simply no evidence to justify a traveller allocation on the East of Harlow site, and therefore my client requests that this is deleted from the relevant parts of policies SP2, SP3 and SP5.
Mr. Spencer, what do you think would be the outcome if it were left in? What would happen?
Well, I think all I can say at this stage is that in the absence of any evidence that the site has been assessed and that it's suitable for such provision, then it's not something my client would support, and it's not something they'd be prepared to facilitate or bring forward.
Mr. Newton, are you able to help us at all from a Latham Priory perspective?
That's correct. We did make that point in our representations, but I had not intended to pursue that point. The point is made in the representation. I don't need to place any further emphasis or elaborate upon that in any way.
So if I were to ask you the same questions I asked Mr. Spencer, if it were left in the allocation, would you be proposing it as part of your master plan?
We would work with that requirement, and we're already looking as to how that could be accommodated through the strategic master plan process.
Miss Bryan, the same question. If the traveller sites were to remain as part of the residential-led master plan area, would you be working with that, or would you be seeking to dispute it?
No, like Mr. Newton, we would work with it, and we have already been exploring the options.
Perhaps we could try to remember to ask the same of the Water Lane scheme under Matter 8 and the Waltham Abbey scheme. But before we leave that point, perhaps could you just come back to what Miss Bryan said about there being alternative land within their client's ownership which could deliver it outside of the master plan area potentially? Is that a site that was looked at? And if not, why not?
I'm not aware of the site that Ms. Bryan is alluding to.
It's the northern part of the allocated site, so site R1, North NWB R1, originally in the Reg 18 plan, straddled both sides of the A414. So it's the bit that is now excluded.
Okay, thank you for the clarification. So I think as Ms. Blom-Cooper explained, the site that was assessed was identified through the traveller site allocation DPD, and the way that the traveller site selection methodology was applied was that we assessed the sites that were promoted to the council, identified by the council. So in terms of the specifics of this site, the site was within the southern part. We've already confirmed that we'll provide you details of the correspondence, but the site that was subject to the assessment process was in the southern part of the site. We didn't receive any comment asking us to look to the northern part of the site at that point in time as they proceeded with the site that had been identified through the Traveller DPD. Thank you.
And finally, just before we move on to the last issue, the other point that Miss Bryan raised about how there seems to be perhaps a different approach taken in terms of the more general screening process, whereas in other areas sites were screened out if they were immediately adjacent to residential properties, whereas in the master plan areas you're deliberately almost putting them in.
Yeah, we believe through the master planning process that we can achieve the adequate separation that might be needed. Just give you the reference for the settlement capacity study. The modelling assumptions are in Appendix 7, and that's EB 803G.
That's the viability.
That's the viability modelling assumptions.
Thank you very much. So we'll move on. I know it's now past the time that we said we've finished, but I think we will push on. It's going to result in the afternoon session starting late, so apologies about that. But I think that's probably the best thing to do. Now, okay. So 5-minute break. Come back at past.
But I think it's important just to set out and explain the context. I'll do it as succinctly as I possibly can. So it's important to explain the scope of work that's been undertaken by the council, and also the work that's ongoing in terms of work that's beyond the local plan studies, which informs then the development management approach. So I'll try and give an overview of all of that and explain how it fits together. Given the iterative nature of viability assessment and the quantity and scale of the local plan allocations, the viability assessments that support the local plan have not considered site-specific or individual infrastructure costs. The reason for this is that the plan contains approximately 80 residential site allocations which span the district, and they range in size from 6 dwellings to over 2,000 dwellings. Therefore, the council has taken an appropriate and proportionate approach to its viability testing, which informs and supports the local plan. Within the work that's been undertaken, assumed costs for the community infrastructure levy have been applied to all development scenarios tested, in addition to making an allowance for potential site-specific planning mitigation through a Section 106 contingency. So the Viability Assessment Stage 2 report, which is EB301, includes assumed SIL contributions up to a range up to £225 per square metre, alongside, in each case, a Section 106 contingency payment of £3,000 per dwelling. The Section 106 payment has been applied as a cost to all assumed dwellings, i.e. both market and affordable. In testing the strategic sites at the Harlow and Gilston Garden Town communities, a range of iterations have been considered through the modelling. These were run with and without assumed SIL at £225 per square metre. It also included an anticipated significant level of site infrastructure work costs, assumed at £32,000 per dwelling. And the detail is set out in EB301C, and I'll refer you to Appendix 2B and the summary there. So after incorporating those costs, the appraisals then indicate, as you suggested, a range of surplus outcomes, which is essentially how much is left over afterwards. Separate costs were also included for servicing of the land for education provision and other uses. For details of that, please see paragraph 2.10.5 and 2.10.6 of EB301. The Stage 2 study, EB3001, has also included sensitivity testing, which considers a range of different variations. The study has assumed that the total land costs, infrastructure provision and developer contributions will be front-loaded. In reality, the Council expects works and contributions will be phased alongside the development. Therefore, we are confident that the approach taken within the study is conservative. It represents a conservative, realistic and cautious approach. The IDP, which as you know is EB1101A and B, identifies the infrastructure that's required to support the delivery of planned growth. The IDP schedules in the Part B report set out the total estimated cost for each infrastructure project, the funding already identified from existing funding sources, and the extent of any funding gap. It is then acknowledged within the IDP that developer contributions will be required to either fill or reduce the funding gap. However, the IDP does not seek to allocate specific developer contributions towards individual infrastructure projects, instead acknowledging that further work will be required to apportion costs, taking into account the SIL regulations and wider considerations. For the Garden Town sites, as you've alluded to, the Garden Town Infrastructure Delivery Plan and the Viability Study will provide further up-to-date details of specific developer contributions required and associated viability for the Garden Town communities, not just in this district but also across the East Herts district and Harlow. As you'll be aware, both the IDP and the Viability Study are currently being finalised, and it is intended that the reports will be published in the week commencing the 15th of April, meaning that they will be available in advance of the Matter 14 hearing session on infrastructure and delivery, which will take place on 23rd of May. For the site allocations across the rest of the district, the Council is continuing to refine the apportionment of developer contributions required. So there's the Garden Town work, which will be concluding shortly, and then for the rest of the district, further work is being undertaken to supplement the IDP. The IDP topic paper is already available. That's EB1101C. That document provides a high-level framework for apportionment and pooling to be taken forward for key infrastructure. As well as a framework for apportionment, the paper also provides information on external funding sources outlined in the IDP, including work ongoing to progress and secure funding. And it also addresses risks of funding not being in place, as well as contingency measures to address that. It also considers the potential role of the Community Infrastructure Levy in the future, should the Council decide to pursue its introduction, and no decision's been taken on that at the present time. Further to the topic paper, for the rest of the district outside of the Garden Town, an addendum to the IDP topic paper is being finalised, and that relates to the apportionment of developer contributions associated with education and highways requirements to sites across the district. That is subject to engagement with the developer forum, and it is intended that the addendum will be published also in the week commencing the 15th of April, again meaning that it will be available in advance of the Matter 14 hearing session for infrastructure and delivery on the 23rd of May. Just worth noting that the Council is also producing a further addenda to the topic paper relating to sports provision and sports facilities. That is not yet available, but will be made available as soon as it's complete. Recognising the iterative nature of infrastructure planning and the need to front-load the development management process by providing as much clarity as possible on matters of viability in advance of planning applications being submitted, the Council intends to undertake further viability modelling for sites across the district, i.e. those outside of the Garden Town, which will supplement the existing studies. So that will bring together the information available in respect of likely requirements for developer contributions at a site-by-site level, reflecting the work that's been undertaken through the addenda to the topic paper. And that will provide more specific viability conclusions for sites allocated in the plan. However, the Council does not consider that the further work I've outlined is required in order to reach the conclusion that the plan's policies and allocations are deliverable as required by paragraphs 173 and 174 of the 2012 MPPF. The Council is confident that the available evidence demonstrates that the cumulative impact of the standards and policies will not put implementation of the plan at serious risk and should facilitate development throughout the economic cycle. However, the Council does recognise that further work will be beneficial in order to respond to the revisions made to the MPPF in the latest 2019 MPPF, and specifically responding to paragraph 57, in order to provide a robust basis for decision making at the development management level. Thank you.
Thank you, Mr. Coleman. Can I just ask a couple of questions for clarification before I move on? So, if the work that you've done through the existing viability study doesn't allocate contributions from specific sites to particular gaps, then how do you know at this stage how far those gaps will be filled and whether those contributions that you've allowed for are sufficient?
I'll start, if I may, and I might pass over to my colleague, but we know based on what is a likely requirement and what's a reasonable assumption of what a requirement for a developer contribution would be on sites of the nature that we have in the district. So reasonable assumptions have been applied, and they're being borne out by the work that's coming forward now in the more detailed infrastructure planning work we're doing, in terms of what we're seeing is actually the actual requirements are likely to be. I wonder if I could pass to my colleague to just sort of explain a bit more about those assumptions and how they are realistic in terms of for the sites in the district. Mr. Dixon.
Thank you. So there are really two layers to this from the point of view of our testing. One is looking at the general sites, which was done on a typologies basis. Which involves liaison with the council in terms of the range of and type of sites likely to come forward, so smaller developments, and what would be appropriate assumptions to use in modelling those. And as Mr. Coleman has said, the approach to those was building on the stage 1 viability assessment, which is EB 300. That looked at the feasibility in the district of scope for funding a SIL, Community Infrastructure Levy, and produced some indicative ideas on how far a SIL could go and remain viable, bearing in mind the policy set that was coming forwards. So the outcome of that work from EB 300, the stage 1 study, was that apart from in the Waltham Abbey area, which relatively speaking, and I have to stress the word relative, is lower value generally, the parameters for viable SIL charging were going to be in the range of £150 to £225 a square metre. So we took the upper level of that to use as an assumption in the stage 2 testing, EB 301. Alongside that, as Mr. Coleman said, we applied a Section 106 contingency of £3,000 per dwelling, really from experience of previous examinations, but also of the reality that since the inception of SIL, in practice, local authorities have tended to rely also to a degree on Section 106, and the whole of the burden has not transferred into SIL. Now, at this stage, we don't know whether the council is going to actually pursue a SIL. That's still sort of open for debate here. But what it means is that we've got quite a substantial sort of pot, if I can call it that, assumed within each of these general typology tests. And if I can just give you a feel for how that looks, because it varies from one test to another depending on the dwelling mix involved. But for flatted schemes, broadly speaking, that is producing, so the appraisals are containing a pot, if I can call it that, of around £7,000 to £12,000 per dwelling. And for housing and mixed developments, typologies, by mixed I mean houses and flats, the range is overall is about £10,000 to £36,000 per dwelling, so per plot. Within the middle of that range, fairly typical assumption is around £15,000 to £20,000 per dwelling on the housing and mixed sites, which, from our experience on those sorts of sites, is is normally enough and is normally about all that would be expected. Bearing in mind that quite a lot of the appraisals, because viability here is relatively strong with the level of values available to support it, actually show a surplus on top of that. So I'm not sure if that gives you a sufficient feel on the general typologies. Then on the larger scheme modelling, so the strategic sites, the different sort of appraisal, undertaken in the knowledge that the council had an emerging policy set which was fully accounted for, following guidance such as in the Harman local plan testing report, whereby an allowance needs to be made not just for, if I can call them sort of standard Section 106 type obligations, but also for the level of strategic work and contributions likely to be sought and required on those sites. So there we built up assumptions based around the £32,000 per dwelling that Mr. Coleman mentioned, being a sort of enhanced version of the range that's set out in Harman, which is £17,000 to £23,000 per dwelling. So we know that from experience the sort of work that needs to go on to knit together these sites and provide all the mitigation is likely to be beyond the sort of Harman range. We ran those appraisals again, not knowing whether SIL would be applied locally or not, but acknowledging the fact that on strategic sites quite often SIL is not is either not viable or is not an appropriate mode for collecting the planning obligations contributions. But we sort of hedged our bets by looking at it with and without SIL. So just to give you an example, on the Latin Priory scheme, and this is information which is in our EB 301 appendices, so Appendix 2B, which is EB 301C and EB 301D. There is a table set out of the overview assumptions and the level of surplus that drops out after these assumptions have been made. So it's important to stress that that surplus is additional to the allowances made within the appraisals. But just to give you a feel for that, the amount of SIL that is assumed in the Latin Priory scheme is just over £14 million, 14.4 million, which is roughly £14,000 per dwelling equivalent across the scheme. So if we add that into the £32,000 Harman allowance and we look at the surplus, which is about another 9 million, what we get to broadly is a picture where around about £50,000 or thereabouts is available as a pot, if again I can call it that, to support the the likely collective requirements on a per dwelling basis. And I think we've got to acknowledge that from our point of view, it's quite normal that the IDP work would be developing. It would be, you know, not put on the shelf. It would be kept as a live document. And that certainly for the purposes of doing this sort of modelling, it is a case of making assumptions, particularly bearing in mind the point at which this needs to be done to inform the policies. And I think overall, you know, hence we came to the view that with a combination of those assumptions and feeling confident that the council wasn't over-egging it, if I can put it like that, in terms of of the policies which have an influence over viability. I mean, that the council can't control the market, it has to work with the market. It can look at whether or not it's being excessive in viability terms on things like affordable housing and accessibility and so on, which we're quite confident it's not over-egging those areas.
I'll stop you there briefly. That's helpful. I'll go on, if you can finish
so
up.
that's really it.
Yeah.
But if that helps give you a feel for the levels of money involved.
Thank you. Thank you. If I just hear from others around the table now. Mr. Koski.
Thank you, Ma'am. I know we all want lunch, so I'll be as brief as I possibly can. To a degree, we have looked at this issue before at a previous session. As you recall, at the end of Matter 4, before the Greenbelt Day, I took you to the Atkins report on the Harlow Infrastructure Delivery Plan that's on the Harlow website at the moment. So it's in the public domain, HEBI1. They have done detailed assessments of everything to do with the Harlow expansion, Gilston, Harlow itself, and the expansion sites that are proposed now. What I've just heard has confused me slightly. It's probably because I need some lunch, but I heard clearly that the sill rate could be up to £225 a square metre, which is probably double what you'd expect to pay in Cambridge, in South Cambridgeshire. A Section 106 contingency levy of £3,000 per dwelling, and then potentially an infrastructure levy up to £32,000. Was that on top, or was that fully inclusive? I couldn't quite put that together. But what I do know is that the median house values in Harlow are currently at £279,000, and the Essex median values are £307,000 for a dwelling. Now, that suggests to me that there are issues there that are not going to add up. Now, we heard that this Garden Town delivery study is due on the 15th of April, I think I wrote down. And in the interim, everything's based on reasonable high-level assumptions, indicative ideas. We don't know whether SIL will be introduced or whether it won't be introduced, what funding mechanisms may or may not exist. It all sounds like reverse engineering to me. But if there is a levy of up to £32,000 per dwelling on an average median house value of £300,000, I think that is going to impact significantly. And if we look at the east of Harlow strategic site, I've seen lots of reporting in the local media recently that that's the preferred location for the relocation of the Princess Alexandra Hospital. And has that been factored into the viability equation? Has that been factored into the heritage impact assessment? Because that's going to have an impact on intervisibility, because a hospital is considerably bigger than housing. So none of this is certain. And we heard at the last session on Matter 4 on viability of the Harlow sites that this council are using AECOM to do the study, and that AECOM and Atkins have signed a memorandum of understanding to work in a similar way, similar methodology. So one would expect that the results are going to be not dissimilar to what's currently on the evidence base of the Harlow local plan with the Atkins report. Now, they said that they worked on a basis of a SIL charge of £87.50 a square metre, and that was the absolute limit of viability as far as they were concerned. This assumption works on the basis of £225 a square metre, which, given that some sites will have to accommodate the Princess Alexandra Hospital, and I don't know if there's an equalisation agreement between the various strategic sites in Harlow, but it's still going to have an impact, obviously. And just going back to the point earlier with the heritage, it's all interwoven, isn't it? If there's an impact on heritage and you have to scale back the amount of dwellings, that's going to have an impact on the revenue you can raise from those dwellings. So the heritage issue and the infrastructure issue are all intrinsically linked. Thank you.
Thank you. From Mr. Spencer.
Thank you, ma'am. Just very briefly to say that my client's been engaging with the council with regard to the forthcoming Garden Town IDP and viability study. And we believe that this work will help to indicate that the east of Harlow site is financially viable at the broad strategic level. That said, we would like to reserve our right to comment further on that matter during the May hearing sessions once the final reports have been published and considered. And in relation to Mr. Koski's comments on the hospital, I gather that the hospital will be represented at the hearing session on Thursday, so I'm sure they can respond to those points then.
Thank you. Mr. Newton.
Thank you. I think the first point to make is that there's no fundamental viability issues in relation to the delivery of the Garden Town allocations. We see no in-principle issue. If I could take the example of Latin Priory, we're dealing with an unconstrained greenfield site and strong residential values. And we have entered into a constructive engagement process with the council in relation to the Garden Town viability work, and we want to see that move to its conclusion through our participation. The point I want to make is that at this stage, this plan is being examined under the provisions of the 2012 NPPF. Now, on the basis of the level of information currently available in terms of infrastructure costs, IDP, and viability assessment, this plan can't really be expected to meet the requirements of paragraph 57 of the 2019 NPPF or the raft of planning policy guidance that goes with that. We can be certain that viability work carried out isn't really sufficient at this stage for there to be a presumption that allocations are viable at the application stage. So we think further viability work must be undertaken when applications are submitted. And that is an important principle which we suggest should be specifically referred to in your report. That's the conclusion that you'd have to reach on the basis of the information currently available within the plan evidence base. Now, we've heard from Mr. Coleman that further information is to come forward, and we're aware of that, and we're involved in a dialogue in relation to that. If that is to be made available during the timescale of this examination, it's important that we have the opportunity to assess that information and to submit statements in relation to it. But I think that rather changes the position. We regarded viability as an ongoing process, with the level of information presented to this examination being insufficient to draw definite conclusions. Now, if Council is to introduce more information, then we must have the opportunity to assess that.
Can I just ask the council about that point? It's something I noted down to say. So if you are preparing new information, both for the Garden Towns, it sounds like it's being prepared, should be ready soon. Perhaps you could just tell us the status of that information and the opportunity that people will have to comment on that specifically for the Garden Towns, but also more widely. You said that some more evidence is being prepared, which will be useful in relation to fulfilling paragraph 57 of the new NPPF. Again, what status would that have? What opportunity, if you intend to rely on it at the planning application stage, what opportunity would anyone have to look at that as part of the plan making process? Or alternatively, should we be taking the approach Mr. Newton is saying, that there's enough evidence now for plan making purposes, but in light of the transitional arrangements, something needs to go into the plan to say that more should be done at the planning application stage? We're interested to hear your perspective on that.
Certainly, thank you, Madam. It is a fairly complex situation, which is why I tried to outline as fully as possible at the start I think there are two strands. So in terms of finding the plan sound under the MPPF 2012, the existing evidence is adequate. That's certainly the council's position, and I'm not hearing anything that's seeming to change that position around the table. But in terms of paragraph 57 of the new MPPF, we acknowledge that the existing evidence is not going to be sufficient to allow viability to essentially been settled at the plan making level. So as things stand, we would resort back to the provisions of the MPPF 2012 and the requirement or the possibility of further viability work coming forward at a planning application stage. However, I believe that with the for the Garden Town, if we take the Garden Town sites first, I believe that the Garden Town IDP, together with the viability study, will provide sufficient level of detail and will be sufficiently robust in order to, if you like, trigger paragraph 57 of the new MPPF, so that viability at a planning application stage would take a different role. It doesn't mean to say that viability couldn't be a consideration at a planning application stage, but it means that the viability discussions would be starting from the basis of an evidence base which has been put in place under this local plan. So the PPG sets out a number of criteria where viability could still be considered at the application stage, but that would be very much looking at variations from what had been considered at the local plan viability level. So it's very much the council's intention that that should be applied for the Garden Town work, which is why we're very keen, obviously, to put it in front of you and to give participants a chance to see that and to comment on it. I'd like to emphasise that we have been engaging closely with Mr Newton and other colleagues on the production of the work, and that we just have concluded a period of engagement with stakeholders on the viability work. We're currently taking into account those comments, and it will be finalised in the coming weeks. For the district level work, that is a different stage. So what I've said today is that we are progressing the more detailed IDP work that's required in order to give us a clearer understanding of the infrastructure costs that can be applied to individual sites. The difficulty here is because the plan is complex and is large in nature, the sites are varied, it's very difficult to be specific about what each site needs to provide. But we recognise that is an important element in informing the development management process. And also, if we are to seek to utilise paragraph 57 of the new MPPF, then we recognise that we need to go to a finer level of detail. So we are about to engage with the developer forum on the further, more detailed IDP work that we have been undertaking. And I expect the outcome of that to come back before you, as I said, the week commencing the 15th of April. So it will give participants an opportunity to review that before submitting their statements for Matter 14. And it would allow it to be considered at the Matter 14 hearing. However, the viability work has not yet been commissioned and would require further time to complete, would require the completion of the further IDP detailed work and a commissioning process. So I acknowledge that work will not be available by that point in time.
Okay.
Sorry, Madam, if I could just add. So from the council's perspective, that won't be available in time to inform the examination process for the local plan.
Okay, if we hear from Mr Newton, because I know you want to come back on that, and then Miss Bryan, and then we will stop there. Thank you.
All I would say is that paragraph 57 of the 2019 MPPF is a very significant shift in policy in relation to viability. And of course, it's not just that paragraph, but it is all planning policy guidance that goes with it. And there are a number of paragraphs within, new paragraphs within the planning practice guidance. I mean, fundamentally, it makes viability an issue to be largely determined at development plan stage, and the onus thereafter is on the applicant to justify reopening viability issues through the application. Now, that's fundamentally what concerns us because, as I think I've already said, on the basis of the evidence put to this examination, it would be wholly inappropriate for viability to be determined through this plan. It may be that information can come forward to a degree and be examined at a future session, but we doubt that really would be sufficient to invoke paragraph 57.
Sorry, Mr. Newton, is that your position even if the viability study and the IDP for the garden towns are concluded in the next few weeks?
I think that depends on the view that you take on it. I mean, we are in constructive engagement with the council about this, and we will continue that process. We have some concerns about the work that's been undertaken, but we have that dialogue. I think if you were to take the view that you would receive that evidence, then I think to some extent that would prolong the examination. There would have to be a specific hearing to examine that new information, both the IDP information and the viability assessment. But at this late stage, it's difficult to see how you could achieve sufficient certainty to invoke paragraph 57. I think the other point, of course, again, I've already made this, is that we're applying the 2012 MPPF here, fundamentally. So there's an issue for you to consider, I think, in relation to that. But I think what's always concerned us is that you've got transitional provisions which indicate that this plan and other plans at a certain stage will be examined under the 2012 MPPF. But the problem is the possible triggering of that onus upon the applicant to demonstrate the need for a viability assessment at application stage. That will apply nonetheless, even though this plan doesn't have to go through the rigour of the new MPPF provisions in paragraph 57, if you see what I mean.
Thank you. Ms. Bryan.
My point was relating to the rest of the district as opposed to the garden towns. I think Mr. Coleman's sort of covered it off, but just clarification that the rest of the district is different from the garden towns, and irrespective of the decision on that, viability can be considered at planning application stage, and that there'll be amendments to policies D1E and the place policies accordingly.
I think the council would prefer to come back on those points at a later session, a later date. We've heard what's been said.
Last point.
Yeah, just one quick point. I've noted that you do have questions on this issue for matter 8, which are more specific, but nevertheless the issue is bound to arise again in that connection.
Okay, thank you. But there's some things. There's obviously some things to think about there in relation to viability and obviously everything else that's been said as well. We will draw a line there. So I know I said at the start that I'd strictly adhere to the timetable, so I haven't done. So I'm sorry about that. But it is late. But I think obviously that there was lots to be said. I didn't want to miss it out or necessarily have everybody come back for a later session. Thank you to everyone who's contributed this morning. Apologies to everybody who's been sitting there waiting for 2 o'clock. It's really only the council that's affected by the lunch break, I suppose, in a sense, because other people have the opportunity to go off. How long do you feel you need? Is half an hour sufficient? Anyone else have a problem with half an hour for lunch at the back? No? Okay, so if we come back at 25 to 3. Thank you.